And of course, then innovation in terms of hubs and innovation hubs and sandboxes. Um, but in the conversations that we've had in Delhi and some of the conversations that I've had on the phone over here as well, meeting folks, I think they just had a conversation outside as well. There is a sense of despondency about the data protection bill, in the sense, will it even matter if we participate in this consultation? Will it matter if we say anything related to how it should be? And we've been there before. Thing is that about 5,000 to 7,000 people have, over the past 5 years, put together their views, submitted their views, written op-eds, articles, done research in order to enable the creation of a better data protection regime in this country, because it impacts all of us and impacts businesses that we are in or associate with or engage with. And what we have right now is a bit of a shell of what it should be. What folks are feeling is that they've taken the bill and all the inputs and effort that's been put into the various versions that we got, which progressively got worse, and just dumped it all, right? But there is a little bit of hope. The sense that I'm getting is that, and this is just on the basis of conversations with people who met them, the ministry is still open to the idea of improving the bill. They feel that it's not as robust as it should be. So we still have an opportunity to perhaps nudge things in a way that things become better for us. So I would urge all of you to participate in the consultation, share your views. If you have questions, please ask. This is a safe space. There are no stupid questions. We did a discussion in 2016 when the Sri Krishna committee had been constituted, before the white paper came out. And I had a lot of stupid questions then. With time, they became less stupid. So idea is, if you don't agree with something, say it. If you think things should be different, say it. We try and have evolve a conversation with people from different backgrounds, so that there's a different way of looking at something and it expands someone else's perspective. So Kiran is here, and I remember, Kiran, that back in 2016 we were having a conversation around consent, and that time Rahul Mathan had come and put forth his idea that consent is a waste of time, and specifically said that we should just regulate for harms and junk consent altogether. And Kiran had been quiet throughout that discussion. He was standing right at the back, Kiran, I still remember. And Kiran asked for the mic, and he just said one simple line that's stuck in my head, still there. You said, our ability to not give consent is the right to say no. And that one statement changed my perspective on things, and I think after that Rahul also stopped making that argument that there should be no consent. So, there are moments of brilliance that we will get when we have a conversation. Someone will think of something and change the way we look at things. The idea is for all of us to participate. This discussion is a supported discussion. It wouldn't be happening without the support of our partners, the Internet Freedom Foundation, Hasgeek, Kiran and Zainab are here, the Center for Internet and Society, and our sponsors Meta and Mozilla. Udbhav from Mozilla will be here a little later in the day. But I'd like to hand it over to Sarvesh to initially run you through the first part of the discussion, which is focused on probably amongst the most important parts of this bill, which is the obligations of companies and organizations, and our rights as individuals. Sarvesh?
Okay, so I'll just quickly go over what the bill says, and then the nuances, the confusion, all that we'll get into in the discussion. So essentially the bill allows any entity, any data fiduciary to process personal data under two grounds. One, if you have the data principal's consent, and two, if you have, or if you have their deemed consent. So the second one already sounds problematic. What it is and why it's problematic we'll get into. As for the first one, so when it comes to consent, the way it works is the data fiduciary has to show a notice, and this notice should essentially say what personal data is being collected and what the purpose is. This is a very trimmed down version of the 2018 bill, where if you look at this list shown here, this was all the requirements in the 2018 bill. So much data had to be shown, including like who the data is being transferred to, and what the grievance redressal process is, etc., etc. But now it's been trimmed down. The consent must be free, specific, informed. That's something that's been carried on. Again, we don't know like what it means for it to be free, specific, informed. It has to show the contact details of a data protection officer in case of a significant data fiduciary, or any other officer if it's just another data fiduciary. And it cannot, the consent cannot be, the data fiduciary cannot make it conditional, services conditional on consent when it's not required. So for example, if the data fiduciary has to provide a service for which that particular data is not required, and they cannot ask consent at that point. That's not something that this bill says it can't ask then. Then there's also the concept of consent manager. In this bill, it's a very small, I think it's like 3 lines. It says that a user can give consent through a consent manager, and this is basically a data fiduciary that maintains a platform for this very specific purpose, and the consent manager will be registered with the data protection board. Users have the right to withdraw their consent at any time, and it should be they should be able to do it at the same ease as at which they gave the consent. Once they withdraw consent, the fiduciary must stop processing the data for whichever it had the consent, unless it has other legal reasons to continue doing so. And the proof of burden to prove that it has shown the notice, it has gotten the consent, all that lies with the data fiduciary when it's like if there's any issue that's taken to court. The second ground is deemed consent. So deemed consent is a new concept in the 2022 bill. It's not something that was there in any of the previous editions. They were in other names, I think, non-consensual processing. So those were some other variants of deemed consent. So over here, deemed consent is essentially saying that a principal is deemed to have given consent for processing of his or her personal data if such processing is necessary for reasons like employment, for a state to perform any function under any other law, for court orders, medical emergencies. Some of the controversial ones are if you voluntarily provide some data. For example, the bill says that if you go to a restaurant and give your number and name for reserving a table, you voluntarily provided your data. So in that case, you've given deemed consent for that restaurant to have that data. Another controversial one is public interest, and under public interest, the reasons are credit scoring, operation of search engines, and for like processing any publicly available data by these search engines. The third one is fair and reasonable purposes. Again, this one is broad and vague ground. It says it'll be prescribed later what these fair and reasonable purposes are. So, and there are a couple of other grounds for deemed consent. Moving on to the obligations of data fiduciaries, they are required to make sure that at least to a reasonable level, that the data that they have is accurate and complete. They have to secure the data, again, by adopting reasonable security measures. All this is not prescribed. What is reasonable, we don't know yet. And if there is a data breach, they have to, the data fiduciary must notify the board and the data principal. Data fiduciaries must not retain personal data after the purpose is served, or it can continue doing so if there's a legal or business purpose, which is now where the controversy lies, because what is a business purpose? The business purpose for that company might be that they need the personal data forever. So that raises questions. And the data fiduciary must also create a mechanism for grievance redressal. For significant data fiduciaries, all the obligations that were mentioned previously apply. In addition to that, they must appoint a data protection officer and an independent data auditor, and they must carry out periodic data protection impact assessment, which is basically to see how well that fiduciary is complying with the provisions of the bill and to keep it in check. What is a significant data fiduciary? Again, this is not yet clearly laid out, but it says that the central government will use the criteria like volume and sensitivity of personal data, the harm to the data principal, and how the data fiduciary, the role of the data fiduciary when it comes to the electoral democracy or the public order and security of state. So all these will be taken into consideration when designing the criteria for identifying significant data fiduciaries. What's been removed from the 2022 bill compared to the previous three editions? Data privacy by design is no longer mentioned. Transparency requirements have been trimmed down. Earlier we had something which said you have to be transparent about your algorithms and how they work, so that's been taken out. The categorization of sensitive and critical personal data and the additional safeguards for sensitive personal data has been removed. Moving on to the rights of individuals, rights and in this bill there's also duties. The rights of individuals, there are a couple of rights. One, the right to information. A user can ask a data fiduciary what data is being processed about them, where it's stored, and a summary of all the activity, like in terms of the processing activities, what it's been taken for, and what's been done with that data. And additionally, all the people that the data has been shared with, all the third parties, all that should be available in one place for the user to see. There's the right to correction and eraser. It's a trimmed down version again of the previous bills. Essentially, a data fiduciary can ask, data principal, a user can ask a data fiduciary to correct any incorrect or misleading data or update their personal data. They can even ask them to erase personal data, but this can be denied by the data fiduciary if it has to be retained for other legal purposes. The example that we have in the bill is, for example, a bank gets the personal data of a new account holder. So even after the account is closed, the bank can continue holding the data for 6 months because RBI's laws require that. RBI's KYC norms require that. So such cases allow a data fiduciary to deny the right to correction or erasure. Right of grievance redressal, this we've covered. So basically, there has to be a grievance redressal process that the data fiduciary sets up, and in case the user is not satisfied with the solution given by the data fiduciary, it can be appealed to the data protection board. The timeline given here is if you don't get a response within 7 days, you can approach the data protection board. But the bill says that 7 days can be reduced or increased as may be prescribed later by the central government. Then there's the right to nominate anyone to exercise your right in case of death or incapacity. What's missing from the 2022 bill? The right to be forgotten has been removed. The right to be forgotten was, it had a wider scope than the right to erasure and correction. That's been removed, and the right to portability, right to port your data, that's also been removed. These were both there in the 2019 and the 2021 bill. Instead, we have something new in the 2022 bill where it's the users have certain duties that they have to perform. They should not register any false or frivolous complaints. They should not share false information when submitting details to data fiduciary or like suppress material information. They should not impersonate another person, and they should only submit information that can be which is authentic and can be verified. And there's also a penalty involved if you do not follow this. The data protection board can levy a penalty up to 10,000 rupees on the user. That's it for the bill. We can move on to questions.
The local languages. I think this is a pretty serious concern, and the Telangana government released their policy about introducing non-personal data for agri-tech. The other concern that I think from a rights perspective is really that just this morning I was thinking about my cousin when she bought her first automatic car, and she said my car is a gas guzzler, and I said this bill is a guzzler in the sense that it really does. Its main purpose seems to be to guzzle more and more of the individual's data, and that in various ways it goes and legitimizes the non-protection of personal data. I mean, if you look at all kinds of provisions over here in terms of the onus of proof being on the data principal to prove that they've been harmed in a certain way, and that they have to provide this proof in a manner that will be considered by the court. Or for the matter, like what Sarvesh mentioned in terms of deemed consent, that if I give permission to dine out to, or rather if I make a restaurant booking through dine out, I'm giving deemed consent. I think all of these are just excellent examples of saying that this bill just legitimizes the non-protection of user data. So I think that needs to be called out. And I think the last point, or rather the last 2 points that I wanted to make was, if we look at the non-personal data framework that was released a few years ago, the implementation of that framework was rather too technical. So imagine that you're trying to ask communities to protect their own non-personal data, but the way the framework is made is that it tells the community that you've got to maintain these data registries, you've got to maintain metadata, etc. All of these implementations, how do you expect people who are not necessarily educated or don't have access to even basic technology to be able to implement over here. And I think, I mean, these kind of, I mean, we've seen more and more policies that have come into play which talk about, introducing algorithms and automating things, etc. And we just find that the implementation is rather too technical. Therefore, one, is it even possible for somebody to kind of implement or, to be kind of oversee what is really going on as a data principle? And the other is, who's in a position to do that kind of technical implementation and therefore questions of access. And I think finally, I suppose this will be discussed in the afternoon session, is there's just been, I think after the AIMS incident and people who've been writing about what has happened with respect to the data breaches, it's still extremely unclear as to which is the agency that a company is really responsible to when it comes to data breaches. Is a company responsible to MATI? Is it actually responsible to CERT? Is it responsible to, I don't know who. I mean, there's a whole lot of agencies and there's simply no understanding and clarity in terms of who are you actually responsible to, and ultimately, what is your obligation as a company to protect and to be responsive and communicate to your users that your data has been breached. So I think these are really questions that need to be discussed and need to also be called out in the submissions that some of us are planning to make to the government. So I'm going to stop here.
So when I first looked at the bill, my first reaction was this is really short, which is both good and bad, in the sense that it can be good that you're not trying to load too many unrelated aspects into a single bill, makes it more implementable. But the flip side, which is true in this bill, is that you don't define things and don't have enough specificity, which then leaves a lot of leeway for everyone else. So for me, 5 points stood out. 2 of them I'd start with from a business perspective, because that's something I'm now a bit more intimately familiar with. This bill is certainly much easier on businesses. To start with, the watering down of the data localization mandate means that it will not lead to the cost increases that one might have otherwise expected. It's easier on businesses because there's deemed consent. That deemed consent says, I can't remember the exact phrase, but for purposes of business, it can be by regulation made a ground for deemed consent. There is no automatic erasure, as Sarvesh said, that you can retain data if it serves a business purpose, which is an undefined term. So overall, this bill seems much easier on businesses than the previous version of the bill. At the same time, I think it also leads to a lot more uncertainty. The reason it leads to a lot more uncertainty is because there's a lot of discretion available to governments under this bill. For example, governments have the authority to exempt any kind of data fiduciary from provisions of the bill, including really critical ones like notice, right to information, etc. Which means they can pick and choose a sector, they can pick and choose a certain category of businesses, etc. In addition to that, especially from a startup perspective, obviously there's no confirmation or denial of exemptions to startups that could be made under the bill in a future regulation. But also the fact that penalties under this bill are capped at an absolute amount rather than a percentage of turnover could, in theory, be extremely punitive for startups. So I think while businesses have a lot less to do under this bill, they also have a lot more uncertainty under this bill, because rules and regulations could be framed in a way that the bill does not provide too much guidance on. So that's from a business perspective. From a user perspective, I think we've already spoken about it a fair bit, but certainly a lot more watering down of the rights available to data principals. So we've spoken about the fact that the way the notice has to be given about consent, there's not as much specificity. It just says purpose. The purpose could be a relatively broad purpose. Then we've spoken about deemed consent, and basically by regulation the government can bring in anything that could be counted as deemed consent, and which basically obviates the need for an individual's explicit consent. And then the right, as I said, the right to information is also something that can be diluted away by the government. So from a user's perspective, the rights are fairly diluted, and in addition to that can be diluted much further. The duties of citizens and duties of data principals just seems like a somewhat unnecessary addition here. There are 4 grounds, as we've discussed, about duties for data principals, and none of them necessarily feel like things that should be here. One thing that really stood out for me was this the reframing of public interest. If you go to the definitions, the first few of them are the regular ones that you typically have in any law in India. But then you have misinformation being a ground of public interest. And that is an oddity that I think needs to be discussed further. And finally, throughout all of these limitations and certainly the benefit of being a much shorter law, you have these exemptions. There are 4 categories of exemptions, and basically that gives a lot of leeway to governments to pick and choose favorites, to bring in the kind of laws to exempt people either from all provisions of the bill or from very, very critical ones. So for me, those things stood out overall: good for businesses, much worse for individuals, and just overall a lot more uncertainty that I don't know if it helps either individuals or businesses.
Just anyone have any questions, any comments?
Thank you for the opening comments. Hi, this is Udbhav from Reworking. Thank you for the opening comments. I completely aligned that this reads more like a data processing bill that enables processing, especially through the deemed consent chapter, rather than a data protection bill. One of the issues I also had while reading it was the absence of necessity and proportionality. The example that they've included within the deemed consent chapter itself of its first section itself, where it says, where you voluntarily give your data to a restaurant, you're consenting to lawful purposes of processing and expected purposes, what's reasonably expected. What I expect is that it's being used only to verify my details, but industry practice has also meant that that data is being used for marketing purposes. So the reasonability of that is, there's no standard to test that reasonability because there is no necessary or proportionality standard that's inserted here. So that is one of the things that enables further processing. And as you pointed out, it essentially treats and tokenizes the individual as a data resource rather than a data principle.
Is what I call as data access protection. It is not data protection. Answer number 1, 0. The cost of business because this bill is 0. The second answer is infinite. Yeah. The reason why it is infinite is because they can basically haul you across for any clause. I mean, so many exemptions, plus, minus, A, B, C, D, E, F. And so you look at the bill and say that, okay, what should I do to be on 0? If the government likes you, it is 0. If the government doesn't like you, it's infinite. So this is what we call as normally license Raj in a very different way. Because if you look at the old stories that I've heard when in the trade union side, the labor inspector would come to an office and say that, look, here is a book which has 540 pages and about 343 sections. Now, do you really want me to go back and look at you and say, which of these sections are you in violation of? Yeah? And so this is a very common thing that when you're in a manufacturing concern. And so what this is going to happen is, because of the way Mr. Bill is done, you're essentially given a Data Protection Act, which is bare, and you have a lot of rules that could be notified whenever you want. And as you're aware, if you're running a business, it's very impossible for you to keep up with these changes in the rules. Who has the patience to keep up with it? So at the end of it, the cost for business is either 0 or infinite. It could be whatever in between, depending upon the bureaucracy. So one way to think about this bill is basically data license Raj in disguise. So, yeah.
What is from an impact on companies' perspective, let's say, what sort of limitations would you put?
I would. It fundamentally adds uncertainty on both sides. I mean, like it or not, GDPR has a fixed top-level cap on the cost of processing data. So as long as you have some kind of a top cap, you're largely okay. We know the cost. We've been doing it now for like 8-9 years. But this one doesn't have a cap. It's either 0 or 0. So I mean, 0 or infinite depends on whoever people want it. So knocking off this deemed consent and basically come back and say that, look, can you at least give some kind of evidence that you took my permission to process the data, and that would be a much easier thing. It is not as if we didn't know about all this. Most of the companies who process GDPR data have what is called as data source attribution, So you know when you're processing data from which source you got from. Most of them know how to do it. It's been like 10 years. So this is not something new. And there are enough places where you can get open source tools for it. So knocking those two off at least moves the bill in the right direction, where as a company you're not looking at infinite costs. And from a user you are reasonably okay. Those are the two things I would probably want to change.
So one of the things that I was planning to do after this bill passed was just for fun, figure out who might have my data and send them notices to understand what they have and how what they've collected and what kind of consent has gone into that. The entity that I was most keen on targeting with those notices was political parties. Now, I'm just wondering, so what would have been useful when it comes to deemed consent is a notice, and so what's missing is that there is no notice for deemed consent. So as such, if someone has your data, you have no clue if they've taken it under deemed consent. So the lack of notice means you don't know who to ask for your data, you don't know who to withdraw your consent from, you don't know who to get your data erased by because you don't know who has it. So as a provision, so firstly, what do you guys think of deemed consent? What do you think of deemed consent? And would you keep it? Would you remove it? Would you change it? What would you do?
Look, I think the law lays out many different parameters of deemed consent. Some of those one could make an argument are legitimate in the sense that you can't necessarily wait for consent in those kind of situations, right? Medical emergencies and a couple of others. As you rightly said, I think there's notice which at the very least has to be given, otherwise it's kind of operating in opacity. And secondly,
like something on the street that says you are under CCTV surveillance.
It has to, I think, surely, and I think that's in some situations legitimate. But it has to obviously, how the notice is displayed, etc. matters a lot. What I would most importantly, so in addition to notice, what I would do away with is the clause that says basically that the government can make any new grounds for deemed consent, because I think that kind of opens up a can of worms. For example, political parties could be added as for political electoral purposes, deemed consent is one of the grounds, right? So removing that open-endedness and adding notice and in general kind of whittling down the number of grounds for deemed consent would be the changes I would think of.
So you would keep deemed consent?
I do think there are legitimate grounds to do so, right? I mean, medical emergencies is being one of them.
Yeah. And anyone else have any views on deemed consent? Go ahead.
I just wanted to push back on the idea of medical emergency being like a...
It's off.
I just wanted to push back a little bit on, even something like a medical emergency being a ground for deemed consent. I think it would have to be slightly more nuanced than a broad sort of exemption, because there are still choices to be made and autonomy to be respected. For example, even if a person is incapacitated in some way, to first check whether there's someone they've nominated or somebody else who can make decisions on their behalf, which is standard practice in medical cases anyway. So, I mean, I would just still be slightly more skeptical of making broad-based exemptions.
You had raised a hand, different question. So we'll come to that. What was that one?
It was regarding providing false information.
So we'll come to that. First here, then here.
I just have a question. On this deemed consent, taking on your point that there are no stupid questions. So just to understand more about this deemed consent, are there any similar provisions in either GDPR or any other data protection law in any other countries which is similar to this, so that we can, as of now it looks like an area where anyone can interpret anything, but have there been any case studies where how this deemed consent would be interpreted in the past? Any such case studies, if you are aware of it? Or even if not in laws of other countries, if such provision is provided in any other law in India where tends to protect where the law is for protecting the rights of citizens. Do you have any such case studies?
Right, so in both in general kind of data protection laws, including the previous versions that were put out for discussion in India, there's always non-consensual data sharing, right? And as Sarvesh said, seems like a much expanded variant of that. And in the previous versions of the bill, at least that we've seen, there have been things around welfare delivery, the kind of again security and of the nation, etc., which have all been non-consensual grounds for data sharing. So this is a far larger and far more ambiguous version of that, but I think in most data protection laws there would be some that would be classified as non-consensual data sharing.
Any lawyers here? Sorry, just let's pick on this point about deemed consent. Okay. So, you had a point as well, right?
So I think if you look at the definition of deemed consent, 8 subsection 1, it says in the situation there are 2 legs to it. The medical point that we're talking about, we will have to see where it fits in. But I think one is where somebody has affirmatively provided the data or the consent, and the second leg is an assumption where she would have provided it, right? So I think the word "and," I'm not sure whether it's the right word to have been used there, because one is you're talking about a proper affirmative consent, and there is a deemed consent within that. And if you look at the illustration that follows, it is only talking about the first principle. It is not covering the second principle at all. So I think there is a little bit of ambiguity in the way they have drafted the language around deemed consent in 8.1, where what is someone, what are those situations where you can say that somebody is reasonably expected that she would have provided such information. So I'm not sure whether there is enough, debate or discussion
in
that
law,
is happening around
how
this.
would reasonable expectation be defined? So, for example, residential colony, and there's a camera facing me, and it records my face. I think the mic is gone. Sorry. So, under those circumstances, like I would reasonably. Just hold on. I'm asking you. So in that situation, I'm someone who does not want to be recorded on video when I'm entering wherever. Right? I create a fuss about facial recognition all the time. What's a reasonable expectation? How is that defined in law?
No, that's exactly what I'm saying. I'm with you. I'm not disagreeing. So I think there is lawyer, because you say who's the lawyer. So I think if you look at the word "and," so I think it's slightly misplaced because they are slightly contradictory to each other, the way "and" is placed, because you cannot have on one hand where somebody has provided her personal consent, that would not be a deemed consent, that would be an express consent. That's really, there's no deeming provision there, right? So how can it be a deemed consent? But
I'll give you another example. There's RCB in Bangalore. Aarti is currently working on a story, it should be out in a couple of days, I hope, Aarti, where when you enter the RCB restaurant, they have a camera that captures your face, determines your age, your body temperature, and your mood, right? Mood as well, right? Some of these things even do mood. Is that a reasonable expectation that you're giving your consent when you're entering a space?
I don't think it would fall under that.
Okay, there's someone at the back. We're still on deemed consent though. Okay.
Give us some clarity on that. That a lot of an individual's healthcare data may be collected, and not for business reasons, but for reasons of that one individual's benefit, it might be retained for a long time. Then would that be regarded? Would that come under deemed consent and be used by any third party for research or profitability or whatever?
I think as it is, there's a complexity with health data because if you register for, let's say I register for a child, for a pediatrician for my child, it goes through Practo. So actually Practo is holding my data. And so I think, the point you raised is a pretty pertinent question, and it also needs to kind of be nuanced in the sense of saying there are so many other agencies that also are intermediaries in the whole health data space. And so therefore, what are also their obligations and this whole question of deemed consent. I think the other question, I completely agree that you can't use a health emergency as an example for deemed consent. I would say also for children there would be a question about deemed consent. What if I'm an abusive parent and I'm giving consent for my child? I don't think that one could be sort of let away with that.
Just go a little deeper on that. What do you mean?
So I think first of all there has been tremendous ambiguity in the sense of who is to give consent, and I think the lawyer raised the question of and being a problem. I'm saying the word consent itself is a problem because number one, what does it really mean? I mean, does it simply signify saying yes or no, or is like just the act of saying book my dinner, is that just consent? So that's the first question. The other is now in the case of a child, for example. If the child is, I don't know, first of all, there's a debate about whether the child's age will be 13 years or 18 years or whatever. But if I am to kind of, let's say my child signs up for something and I am supposed to give the consent over there. What if I'm an abusive parent? I don't know, I mean, if that's the way to kind of proceed for children in this case. I mean, as it is in this country, we don't have that much discussion around abuse, and abuse doesn't have to be physical for children. But it really is very unclear and very concerning to me as a parent in terms of what's going to happen to my child's data over here, and what if tomorrow I turn out to be a mentally abusive parent, and what would be my child's privileges in that case, or what is her recourse to safeguard and safety?
You are collecting data at some point in time and you're using it for that purpose.
Give me examples.
So, you could give notice but not consent. So, I'm coming to the difference between that. So, there's the same example that you said. You're walking into a building, there is a CCTV camera out there. They say that you are under CCTV surveillance. They can't, you can't go there and say that, hey, no, don't take my snap, right? Don't cover me on camera. It's not possible. Similarly, there could be an employee.
So, on the question,
yeah.
Let's say they put facial recognition software at the back.
Yeah. So that's what I'm trying to say.
So is that a reasonable expectation?
No. So are you saying that you should not be covered on CCTV camera because you're entering a place which is secured by CCTV camera?
The CCTV cameras all over the streets.
Yes.
And
so every 100 meters are you going to sign a consent?
Every 100 meters is my facial data going to be recorded and processed using software at the back? Facial software at the back?
It would be used for audit purposes. When there is, suppose there's a crime that has happened, they would go through all of that.
That's a
legitimate purpose.
A great point to raise. Yeah. Let's talk about purpose limitation. So we'll next, but you had the mic earlier. You had a point to make, right? Someone right behind you. The lady there, you had a mic earlier.
Same is the case with, say, employees, right? And there's a security control put on a laptop. You can't go back and take a consent every single time. And what if one employee says that...
I'm saying that's a different relationship. I'm talking about...
But it's consent. End of the day, it's
no, but then you can take that consent when an employee is signing up for a job, right?
Yeah, but then you're going to take a broad consent.
You will take a broad consent, right? So we'll talk about purpose limitation, because if you take consent based on particular purposes, then a broad consent works because it's limited by the purpose for which you use the data. But my question is that there is deemed consent on ambient data in particular, which is the trickiest to deal with. The place is my consent for security purposes to be captured, and is my consent also for facial recognition thereafter? Is it then that consent also there for inter-agency sharing or sharing with private parties? Where does it end is the question. Because the whole idea is to limit the data sharing, right? To protect my rights, your rights as individuals. So I'm saying, where do you draw the line? Because that line has to be drawn with this bill. So where do you draw the line? So we have a bunch of hands up. Can I just see them again so we can go around? Okay. So, Vaneesha, we have to just wait. There's someone here, then we'll move here, then we'll come to you with the mic, then we'll come here, there and here. Sorry.
Okay. So
remember the sequence, I'll forget, okay? Sorry, go ahead.
The answer to her question regarding another jurisdiction having the deemed consent obligation is Singapore. Singapore has deemed consent by notification, which I think could be imbibed into our bill to answer some of the doubts. For example, I understand his concern which says you can't ask a person every 100 meters for their consent. Right? Instead, if there was a notification that stated that when you're walking on this road, there is CCTV footage being taken, this could be helpful in a scenario where, let's say, a crime takes place on that road. The facial recognition that you are worried about could help catch the person who committed the crime.
But then you don't do facial recognition until there is probable cause.
Yes, the processing of it should be.
But you don't do it by default, right?
Sorry?
You don't do facial recognition by default.
Exactly. So that's what my statement is. It should be for the purpose. Facial recognition, the collection of data for facial recognition should be okay, but the processing of it should be post, let's say, a crime taking place or for a purpose as such.
Okay. So there's someone in front row. I've forgotten the sequence. Who was next? That's it. Sure.
Hello. I have certain observations and questions based on my recent experience with the Mental Health Care Act.
But we're looking at deemed consent right now.
Yeah, and talking in conjunction with that, given that the electronic data entry of mental health data of patients in DMHP settings. So there, in terms of implementation, there's a lot of problem with consent, getting consent, where they have tried to do it. And I feel that this deemed consent would be used as a way to bypass the issues in getting consent, and the whole idea of consent will be removed if this is allowed because of the practical difficulties in getting consent in such settings. So that is one observation I can think of. And another thing is, again, the data fiduciary in this example would be this mental health state authority is who the other act talks about as the owner of the data or the caretaker of the data, but I don't see a congruence between how they will be able to fulfill the obligations listed out in this bill. So that is something I thought I would do.
Government agency will most largely be exempted, right?
Yeah, so the question is again, they cannot be exempted in totally in terms of this one because they're talking about providing the data for research and other purposes. So again, the control creep can happen, the scope creep can happen there as well. So how are we going to, because especially when there is the sensitive personal data and the non-sensitive personal data, the distinction being removed in this version of the bill, how will that be taken care is something that we should think about.
Okay, there's a, you had a point, right?
Is the data collected via deemed consent and the one where you give open consent, they are all going in through the same pipe? So will the data fiduciary, whoever's collecting it, the company, can they lump it together and process it also similarly and connect it all together? Or will it have to, is there anything in the law, or can we even imagine that these things technically can be kept separate in collection and processing?
Absolutely equivalent, and in fact, something that is grounds for collecting might be different, but everything after collection onwards remains the same for both kinds of consent.
I think that's actually a fantastic question, by the way, because what if the inferences drawn from that data? Should the inferences drawn from deemed consent data be treated separately from it? Is it
yes,
absolutely.
Related to this piece about explicit consent and deemed consent, consent required. I don't think you can cover it up with deemed consent. So they would be two different scenarios.
No, her question is, would the data be mixed and then inferences be drawn from it, and so therefore should they be treated completely separately, including what you draw from it?
Yeah, the question of are they getting into the same pipe? The answer is that if there is a pipe for explicit consent, you don't get deemed consent there. And if there is something that's coming through deemed consent, you're not getting an explicit consent there.
Right? The question was post that, when they're collected in a database and they're mixed together.
Processing two different sets of data?
Are you processing them separately is the question.
So if you have got a purpose for this data and you've got a purpose for this data which are different, right? Then what is the same processing? You will not be processing it for the same purpose, right? So unless the purposes are similar, there is no similar processing. And if the purposes aren't similar and you're taking explicit consent in one case and you'll be taking implicit or deemed consent in the other, then there are two different sets of data.
For deemed consent, you don't know what the purpose is.
With deemed consent, you don't know the purpose.
You know. There's a legitimate interest. There's a purpose and a legitimate interest.
So deemed consent 8.9, Sarvesh, if you could put that up, says where the legitimate interests of the data fiduciary in processing the rights of the data principal. I don't think anything becomes more broad than this.
think the other question to Rohini's question is, what if I as an individual give deemed consent in one situation but explicit consent in another situation of the same service?
Okay, sorry.
Terminology deemed consent, right? Need grounds of processing, but instead over here we've used the phrases deemed consent. So the problem here is that, does that mean that the data principal tomorrow can also withdraw consent? Because probably at the time of collection of the data you don't have to give consent, but then later on the data principal could potentially exercise the right to withdraw the consent. So, I mean, this could potentially become an issue in the future if it's not clarified.
Same point, right? 8, 9, where the reasonable, whether the legitimate interest of the data fiduciary. So also, it's like an infinite loop. It could be an infinite loop. You withdraw consent, you deem consent, you withdraw consent. Where does it end?
Yeah, and the infinite loop ends in that
Bangalore.
So I think that is a fantastic question, Rohini. Thanks for that, because I feel like basic questions sometimes really make us think very deeply about basics, and I think that's fantastic. When businesses should be taking explicit consent and when they should be taking deemed consent. Am I right in this reading? Because they give a series of examples of what scenarios are deemed consent, but they don't really specify to businesses that in these cases you should take explicit consent, and in these cases you can take deemed consent. Again, I want to know if I'm right. That's my view.
My reading on this is that should be the explicit consent. The explicit consent is the norm, deemed consent is the override.
But you wouldn't know if they're taking deemed consent, right? Like, how would you know that they're taking deemed consent? You're just giving a number and it is deemed that you have consent. You wouldn't be aware that you wouldn't be aware that you've given deemed consent. You wouldn't know that.
On that point, you're right. I mean, I don't think it's enforceable by the user, but theoretically it is enforceable by the board, etc. Right? Yeah. Because the board can come investigate you and say, hey, what was the ground for processing this data? And at that point, you have to say, hey, this was deemed consent under such and such. Yeah. So theoretically, someone else can enforce your rights. As a user, you won't be able to enforce your rights.
So, do you have the right to withdraw deemed consent?
I don't think that's the intentionality. I don't know the exact wording, but I don't think, given the grounds that they've listed out, it is intended.
Do you have the right to erasure of data when there's deemed consent?
I do not think that's the intention here.
Not the intention, but do you have the right in the law?
That's what the right to forgotten should be.
It's not.
I mean, it should be that.
Do you have? So it should be, but do you have it currently? Is this?
You will also take a question further, which is that even if you have the right to be forgotten, or that you want your data to be erased, can the service provider actually erase your data? Because they will be technically limited from erasing data. It's not as simple as saying, I just want to delete my record.
So I just wanted to, with the introduction of the consent manager, like with explicit consent and using the consent manager, there's also a concept of, say, having consent fatigue, and you're using the service of consent manager like an app perhaps, or any sort of a web-based sort of form or whatever. But you're withdrawing consent through a consent manager or otherwise, and these services are now sort of utilizing any sort of notice and choice forms that are coming up. These are like quickly you're just like swiping through them, and so basically the notice and choice framework that is being displayed, which is even truncated now, is not working anymore. So privacy self-management has gone down the drain, and so has the notice and choice framework. And the consent manager is now made what privacy was supposed to be, right? What was privacy supposed to be, which was a right, into a service, a consumer service, which you have to purchase or subscribe to now. So I just wanted to understand if you had any comments on this, because this bill is actually proposing a completely new market for privacy, which was something that we were actually fighting for as a right. So just wanted any comments and anything.
So here's a couple of thoughts, right? I think consent is going to remain limited because of all the reasons that you say about consent fatigue, etc. There's been people have done in experimental settings done translations, shortening, images, etc. And the results are extremely mixed. So I think that limitation, unfortunately, will always stay with us. Does that mean that we do away with it? No, I think it's the, as you quoted Kiran saying, it's the ability to say no. To the extent that consent managers facilitate that ability to say no, at the very least telling you where all have you given consent, I do not think it's a bad idea. Because right now I don't have the ability to say no because I don't know where all I've said yes. So to that extent I do think it is useful, but I think your larger framing of saying that are you converting the right into a service remains, and it I think is valid for a whole bunch of other provisions here as well. But I do see consent management is useful. Now the question becomes, is it something that should have literally been hard-coded into law? That I do not know, especially for a relatively untested technology, whether we don't even have evidence of whether it works, helps, doesn't, etc. Should that be a part of law when so many other things aren't? So that I disagree on, but...
Yeah, so basically giving away data is a part of the law, but protecting it is not. That's basically what they're doing. But there are a couple of points here. Sorry, so here, and then...
I wanted to take a different view when we say consent. Why do we fear from giving such consent? We need to understand the flow of data. Data will flow, you cannot stop it. You cannot say I want to give data to this. So I book an Uber coming here. Uber will share with Gmaps or GPay. Right? You cannot say for this I'm not going to give data. I cannot give consent. For business purposes, it will be shared with other things. So what we need to look on this is what happens when you give consent to any data. Does the law protect your data for everything? It says data fiduciary only gets the data, it will have to implement appropriate TOMs, technical and operational measures, right? So once the consent is given.
So two things just on that. I see where you're heading. My thought process on this is that number one, the data is a given. The most important thing is the fact that data is going to be shared is my data. I should know that it's being shared, because then I have the right to not give that consent in the first place. In the sense, if I know where all my data is being shared and sold and whatever, it then creates a competitive market where I might choose one service over another. So transparency is an integral part, therefore notice is an integral part, and therefore in deemed consent, if there is no notice mechanism, then effectively I have no visibility over what's happening to my data, and so therefore I don't have the right to say no, for one, right? Part two, and I've lost my train of thought here, but the other is just because it is being shared, and we move to the discussion on purpose limitation, but the fact is that the other thing that we need to know is for what purpose it is going to be used. And then once that purpose is served, that data should be ideally withdrawn or deleted or erased, or I should have the right to do that because my purpose is served. The fact is, it shouldn't be that once it's out the door, anyone, anywhere can do whatever they want with it. Because effectively, that's the difference between it being my data and the data of the organization that collects it from me for serving the purpose for which I'm allowing it.
So what we are actually talking about principles of data processing, transparency, accuracy, minimization.
The law doesn't have a lot of that, is the point.
Transparency and in fact for withdrawal consent, withdrawing of consent and benefits for
we get to withdrawal of consent, but say you had a point in this something.
That if Google Maps states it when you're using an Ola, it feels okay in this point somehow to the normal user that it's okay, fine, let the data go to say Google Maps because it's fulfilling this particular purpose of making me reach point X, etc. But what we don't realize is the far-reaching repercussions of the same, right? Because today it's Google Maps and Uber sharing their databases and the links between them. But tomorrow, you might have health-related data, you might have this very same data, location data in fact is so private and personal and intrinsic to you, so you never know where it's going, if it's going to an intelligence agency, etc. So as users, we've been black boxed from the entire concept of how the data is being processed, right? And here deemed consent is where it's being misused, right? But data is not being used in silos is what we have to constantly remind ourselves, right? Because even today, suppose I go to Amazon, I accept cookies and I accept
Got the point. So there's just three things. We have to discuss purpose limitation, and the other two things I've forgotten. Sorry. So purpose limitation is one, but withdrawal of consent and erasure is the other. There was one, right? Sorry, there was you have the mic here, then we'll come there. We'll come to you. Yes, duties is the third one. You've been waiting for that for a while. Sorry.
Works with consent. You need the two provisions together. The manner in which it's supposed to get consent is supposed to give notice, have purpose limitation, is supposed to disclose the broad grounds, and also disclose the recipients. Deemed consent is an exception from that. There's no notice. All you need is to satisfy those two legs. It is voluntarily provided, and there's a reasoned expectation that has to be provided. The moment you satisfy that, the exception, there's no incentive to actually follow through on the consent laws, because the exception is brought out to cover your uses. And the user is not, the purposes can be anything because you're getting deep consent for those purposes, simply by not notifying the user. So the exception is turning into the norm through that very provision.
Neela, is public interest defined in law? Because public interest is one place where deemed consent happens, right? No, but is there a law that defines the phrase public interest? Or is there a definition that's being created through this bill? And then it's been expanded. What are the definitions here? Like, Telegraph Act is not necessarily in terms of privacy or guiding light, right?
Just
it's your surveillance law.
Yeah, so it enables surveillance for public interest purposes, national security, which is broadly defined, and there's no. There have been attempts to define and set the contours
So
of
case law public interest is defined. In law is public interest defined. So for example, is credit scoring public interest? Is recovery of debt public interest? Is operation of data public interest? Again, processing of publicly available purpose data. So for example, if all of our photographs are on social media, publicly available, so then can Clearview AI effectively scrape all of it and build facial recognition databases because they have deemed consent under processing of publicly available data. I'm saying the phrase purpose public interest is being defined in a law without any history of all of this stuff.
Also another situation. If there is a data processing of it, something that
I love that point. That's a round of applause, please. Processing might be public interest. Availability happens through a breach. Fair enough. Sorry.
Just one point on that is, but if the legitimate interest of the data fiduciary outweigh that of the organization, so can I establish and assume that the legitimate interest of consumers do not apply to the other clauses of Section 8? For example, they said that an employee can collect biometric data for attendance, even though there are other less intrusive means available. So can I then assume that my legitimate interests are only in the last residual category and not on the ones above that?
Anyone has an answer to this?
I think it's an addition, so that's separate. So this is another grounds for deemed consent. So this does not apply to the other 8 grounds for deemed consent.
Right. So my legitimate interest won't matter for the first 8 consumer legitimate interest then.
No, I'm just saying it will apply to deemed consent, right?
It will, but kind of all over the place. I'll let the other person go for now. Discuss this later.
Related to this? Okay. Related to this, any of anyone else?
I have a quick additional question. Yes, and I use my mic. The data that is collected by deemed consent, if it is used for things. So what I don't understand in this law is if I give any data by it's deemed that I gave consent. Will I be protected if it is violated in some way that violates my privacy? Like for example, like census collection data, which I find is a very clean, defined way of collecting data, collects very minute data from us, but it's only allowed for aggregation. It can be public, it can aggregate, and only that can be shared with like the public. But you can't use how many people live in my house to sort of sell me something, or the political party can't come and say that you have 5 votes, so I'll come to your house. That data, they're separately used. So, but if someone does that and they've used census data to do that, then they pay a penalty. So these penalties that under the this law, do they apply to the wrong use of data collected by deemed consent?
So let me try to come in on that. Firstly, one of the things I did notice in this bill was harms in the definitions is extremely narrowly defined. So it only includes things like bodily harm, impersonation, etc., right? So whenever there's harm being caused under this bill, it's going to be really difficult to for you to make the case why a certain thing is actually harmful to you, because it's not bodily harming you, nobody's impersonating you, etc. It's the very limited definitions of harm in this bill. Secondly, which I think one of the issues that have been brought up as well, is that if it is deemed consent and there is no notice, then how do you even know what the purpose was? So I might argue that data I've collected from you was meant to come and figure out how many people are eating in your house and how much they're eating, etc. Right? If you don't have notice, how will you know the purpose? So that I think is the problem with deemed consent, that in the absence of notice, it could really legitimize many different forms of data usage.
I was asking this is also sort of related to the giving explicit, when we are not giving explicit consent, but certain things we feel overall the public feels it's okay to give data, like my face is collected, there's a CCTV looking at me in a mall because it's collecting footfalls. So I'm fine with being counted as one of the many members who entered the mall, but if that data is used for something else, will this law allow the government to say that no, your right to privacy has been violated? So suppose it's used for FR, but you collected it from all these people who don't know what it's for, and by law, by deemed consent, maybe you won't get a chance to say this purpose is not allowed. But I mean, along with the consent architecture that this law sets out, is there also an architecture for overall protection of rights? Is what I'm asking.
Sorry, someone's coming in. Okay.
You've been waiting for a while.
So I just want to follow up with a point that was made quite well, that some purposes, for example, verifying an employee's attendance, can be done better through non-intrusive means rather than more intrusive such as biometric data. So for the whole deemed consent clause, and this is from a purely legal
perspective. Airports can also be done through more non-intrusive means.
It could be done through an alternative means. So one way to restrict the deemed consent clause is to say purpose limitation. Another way is a clause probably that we could add that provided that if the purpose that you're seeking could be achieved through other means, they're a little different from purpose limitation. As prescribing that if you could have
there was something in the earlier versions of the bill that that sort of said that in terms of limiting, like if there are no other means, or for example in case of Aadhaar, what it says is that even for the government about subsidies, that either do Aadhaar verification or allow people an alternative means to do it, right? So the provisioning of an alternate means and saying this all or nothing kind of an approach also exists. So if I don't want to use my fingerprint for biometric attendance, then they might have to provide me another an alternative. And that not just for employers, but you could look at multiple. So this idea came to mind when you were saying that. So quickly on deemed consent side. There you've been waiting. We move this side and then we'll come back.
Sure. So I just want to talk about the Taylor Swift School of Deemed Consent. So what happened in Europe when she was touring was in one of the venues where she was performing, she had screens set up with unreleased audition tapes, and every time visitors would come and stand in front of it and look at those tapes, there was actually a camera behind the screens doing facial recognition of every person that was coming and standing to compare it against a database of known stalkers of Taylor Swift. Now, there are a few problems that come out of this. One is that this has to be in the zone of deep consent. It cannot be express consent, because if you make it express, then it defeats the purpose of doing it. You can let the stalkers deploy countermeasures like putting a fake nose on, or just shaving their head. Now, and that is captive FRT. What essentially it is doing is, it is scaling what would otherwise be a team of 20 security guards with a book of all the stalkers in front of them. All it's doing is it's speeding up that process. Now, if this is legitimate, whether it's legitimate, that's a question, then should this be restricted by a law? And if this should not be restricted by a law, how do you keep it as open as possible to allow this while also disallowing other forms of harmful exploitation of deep consent?
That's a crazy question. This would not define the rule. This is quite an exceptional situation. Can we put up the clauses to see where it would play?
Actually, it may not be. I mean, just to answer your question.
Yeah.
For dealers with concert and your consent to facial recognition will be in there. So it's in fact may not be deemed consent or notice just for you to show up in the booth. When you buy the ticket, you'll probably click something that consents. So it's not really as exceptional.
Smart lawyers, if she, and I'm sure she can afford them, will put that in.
Yeah, so on the deemed consent part, in part C of section 8, so it says data fiduciary must cease to retain personal data once it is assumed that retention is no longer necessary for legal or business purposes. Now that is so broad because if you go to a restaurant and you give your mobile number and your information,
So
and you can
talk about erasing retention. I just want to close out deemed consent.
Is invoice data deemed consent?
Invoice data deemed consent. Okay, give me context on it.
So you give me an invoice as a business to me. You're billing me, or the reverse happens. Can the other party take it and say you agree to share with me, and so I'm going to share all your invoice data to a third party to do a profile check?
For small companies is when you show your invoices to the financier and say that therefore there's money coming in, so you give me a loan. Now what you're doing is sharing somebody else's data.
Is our invoices personal data?
For the company, business.
For the company?
For the business. It is not, I wouldn't call it personal data, but because deemed consent.
Sorry.
It's not for business.
The definition of personal data includes company data.
A definition of personal data includes company data.
Invoices and serial numbers. And that's I think a legal requirement for audit. Simply deduct the volume of a business by collecting invoices from various different vendors from the same company. And so the invoice discounting service can estimate the volume of a business that is on its own client, simply because that other business is issuing invoices that it's discounting.
See, that's the definition of person. So I think the bill is essentially safeguarding the data of a data principal, right? So data principal means the individual to whom the personal data relates, and where such individual is a child includes the parents or lawful guardian of such a child.
Okay, how are we doing on time? Way past? Okay, so
just one question on the
yes, so very quick questions, very quick answers. I'm sorry, we need to move to withdrawal of consent. We have two other topics.
No, it was a broader point about how people are viewing this deemed consent. Someone else made a point. I almost see deemed consent being the norm and express being the exception, because I, as an entity, would want to rely on any of the deemed consent conditions in order to process data, rather than have to go get express consent, which has all these other standards I need to comply with. So Nikhil, the point you made earlier about deemed consent is recognized for verification of attendance. With this deemed consent, do you now have the right to say, no, I don't want to give biometric data for attendance?
You don't.
You don't.
You don't.
That's exactly the point, that I think deemed consent might be the
No, but for employers there are exemptions anyway that are in play. I'm saying that if you look at the criteria for deemed consent, you're actually bang on about this. Like deemed consent is the norm. because of the scope of deemed consent. So, simple question, why have a data protection bill if this is where it's going? I mean, the question is, where's the exception is the protection, like you were saying, then why are we doing this?
Data protection, not data access.
It's a data access bill.
That saying that you will share your data, the data will be shared, it's what the company or the fiduciary does with your data. The data protection should be there, data flow should not be stopped.
Okay, let's talk about rights then. Sorry.
We all have been talking, sure, okay. We are talking about personal data protection. What are we trying to protect and why? Tell me. What are we trying to protect and why are we trying to protect it? I, as an individual, I'm not talking about everybody, I want to protect my data for two reasons. One, it may be used for criminal purposes, which we keep aside because that's where we bring the government in. We can't take care of the law, criminal law. The second one is that my data makes money for somebody else. So data monetization is happening with my data, right? And that I'm not comfortable with. If somebody is making money out of my data, there are two things that we do. We have interaction and we have transaction. Interaction is when you go to a hospital and give you a fill up a form. Yeah, sure.
So these questions were considered in Puttaswamy, and I think the factor is that we are protecting our fundamental right to privacy when it applies to companies is what we're looking at, and you have a certain set of reasonable restrictions that are placed on government processing of data. There are certain reasonable restrictions that are being sought to be created for companies processing data, because there are second order effects of the release of data that you cannot estimate right now. So you're protecting from harm from the get-go by giving you control and preventing harm at the same time. That, from a zoomed out perspective, is what the bill is supposed to achieve. Withdrawal of consent. Do we have the term for the withdrawal of consent? Is withdrawal of consent and right to erasure, is it there in the bill in any shape or form, or is withdrawal just lost? Anyone? So any thoughts on purpose limitation? So you've been waiting for a while, you had some points.
I was actually going to refer to the duties part that came in towards the end, because I feel that is, I would like to understand the interpretation, because falsifying my own data is a way of protecting myself. So I'll give you an example. When purchasing alcohol,
I'll be discussing later in the day.
Okay, so the fact that I'm not supposed to falsify data and I can be punished for it, can we discuss later?
It is going to be discussed later because. So falsification, all of that speak.
So the short answer is really, if I lie in order to protect myself.
One second. So there is pseudonymity, there is other mechanisms.
Because there's very clearly a penalty here for lying. And one of the best mechanisms to defend myself, my privacy, is to lie. And so
every place that I enter, I change the spelling of my name and I change my mobile number where I have to fill out physically anything, which is so fair enough.
So that's why I read the duties as a very problematic thing, because while we may be focusing on the deemed consent and express consent and so on, one of the best ways is to not release your data.
But
you are going to be
it's in line with the constitutional. There's one constitutional school of thought that says fundamental duties are more important than fundamental rights. It kind of draws from that. Sorry, anyone? Any questions on withdrawal of consent? Any thoughts? Anyone has any other points to make on this? Or are we done with deemed consent and bored with rights?
Sorry, I'm sorry, I may have missed this. I just wanted to make school of thought a while ago, but regarding withdrawal of consent, are we in alignment or are we asking for a clarification that right should only be available where the consent that we're discussing is the Section 7 explicit consent and not the Section 8 deemed consent?
Yeah, we're discussing Section 7.
Understood. No, but because the words used there is just that where data has been collected or on the basis of consent.
I think deemed consent
It is taken to be consent, right?
Yeah, like if you read the first line for section 8. Yeah, a data principle is deemed to have given consent, and here onwards, any principles that apply to consent.
Correct. So basically, it's deemed to have been given. That's it. So anything that applies to consent will also apply to deemed consent. So therefore, withdrawal of consent.
Sorry, yeah. So
is
just
possible.
on this point, because section 7, where it is the basis of processing of personal data, the data principal shall have the right to withdraw her consent at any time.
So you may have missed this. I made the point about the infinite loop of withdrawing deemed consent.
Yeah, sorry, I may have, but the question is, for example, one of the grounds for deemed consent is if data processing is required during a court hearing or during the course of litigation, right? I can't imagine a scenario where I can withdraw the right for my data to be processed with my deemed consent. For
what about credit scoring?
Yeah, again, another matter of where I may not have the ability to withdraw my consent, although it is called deemed consent.
Why should I contribute my data to credit scoring?
No. If you have, like, let's say if
it's a part of deemed consent, why should I?
No, I agree. So deemed consent itself would, to my mind, has two parts, right? One in which something like this, the ability to withdraw doesn't make sense. For example, where it is being processed in the course of a tribunal hearing or a court hearing, and one where, for example, I've provided it voluntarily with with my reasonable expectations and things like that. In that scenario, I should be able to withdraw my consent. So, is there a bifurcation that we're trying to draw that we want the government?
So I think you're asking if 7.4 is applicable for deemed consent.
Largely, and if it is if we do want it to apply, which we do in some cases, can we carve out in deemed consent which it should apply to and which it should not apply to? Because there are definitely some examples where withdrawal of consent should not be applicable, should not be available, and in some cases where the ability to withdraw consent is important.
Okay. I think in my reading, 7.4 seems to be only for explicit consent, but I think some people think it's applicable for deemed consent, so probably one of the areas where we need more clarity.
I mean, if you're going to argue that...
Sorry,
you argue that deemed consent and consent itself are not same, a lot of questions will also arise in terms of data sharing, or because in every other place where consent is mentioned, rights relating to sharing, to processing, to notice, all of those things apply to consent, where consent is assumed to also include deemed consent. Because, on the one hand, you're saying that you won't be able to withdraw your content, but on the other hand, you'll also argue that companies won't be able to share this consent, because once again, there it's consent, it's not specifying whether it's deemed consent or consent. And I think the language also makes it pretty clear that, as soon as they say that it is deemed to be consent, then it remains consent as soon as it is deemed for that purpose. And I think that's something that brings us back to the question on, can you bifurcate data, and can you draw those distinctions between data collected through deemed consent versus explicitly? I think deemed consent is relating to data processing and not to data collection, because you are deeming consent for processing of data that has already been collected by a certain entity. So once this data already exists with the person, the restriction only happens in terms of what purposes they're using it for. What
That's
purposes
the collection
they're
also. It applies to collection as well.
Can you give me an instance where...
Ambient data. Ambient data. Ambient data.
Yeah.
CCTVs.
Yeah,
It
so...
applies to collection also. Collection and use, right? Collection.
No, but that collection is happening with explicit consent. It's the processing that happens through deemed.
No, not necessarily. Not necessary to that, right?
So public places, CCTVs are collecting data through deemed consent. Is that your point?
My photograph on Twitter can be taken.
Yeah, so
That's
exactly.
that's
Your
consent.
photograph entered the stream of data in Twitter through your consent.
Right, but anyone can scrape it off Twitter.
Correct, and that's processing. That's not collection.
No, that's collection also.
It's a completely other than collection. If I scrape it off Twitter, then I'm not processing it for Twitter. I'm collecting it.
Data to be withdrawn. Can I also undo all the processing that has already happened with the data that was collected some 2 years ago?
I don't think that's that part is clear. I think it says it has been done before the consent was withdrawn.
So there's a limitation to the right to erasure for legal purposes. And then withdrawal of consent is for legal and business purposes, right? Within a distinction.
That is voluntary, not voluntary, but the business
Right,
is removing data on its own. The business has to remove data on its own except for business. Passive.
On its own.
Yeah. So once the purpose is satisfied, the business is supposed to remove that data except if they have a legal and business reason for not doing so. So essentially what this would mean is, for business reasons in particular, individuals can proactively ask for erasure, but it will not happen in that sense automatically by the business.
So does the right to erasure exist effectively in this bill?
Yes, unless it is circumcised by the...
Such broad terms.
But as legal though, the business one doesn't stand. You can still, for your business reasons, if you actively ask for it, that is not a ground for denying you that right. So I think if you ask for your data to be erased, I don't think the business can turn back and say that, hey, I have a business reason for holding it, because that's not the ground under that clause. Whereas the business can say, hey, I didn't delete that data because I had a legitimate, in general, I did not delete that data even after its purpose was served because I had a legitimate business right to do it.
I think because this bill has been called the as may be prescribed bill, right? So how data is to be erased, that is yet to be prescribed. So the right is there, but the contours of it is, if you see 13.1, it says data principles, you have the right to correction, erasure of personal data in accordance with applicable laws and in such manner as may be prescribed. So this is still something that's still wide open in terms of what we'll come up with.
Sorry, you were talking about withdrawal of consent earlier, so I want to go there.
What he mentioned, that can you go back to 8.6? Yeah, so it says the retention is no longer necessary for legal or business purposes. Now, how do we kind of say that the business purposes has ended? So, because obviously my data can be continued to use for different business purposes. I keep on getting phone calls from so many different businesses, and I don't even know from where they have got it. So in the illustration A, it says very clearly that once someone deletes the account from social media, it should be immediately removed. But when I am giving deemed consent for booking a railway ticket or booking an Uber or booking a restaurant or a movie theater, I don't know when the business purpose would end for that.
The way I would articulate this clause is it basically kills storage limitation, which used to be a provision under earlier laws. So there is no storage limitation. As you rightly said, it's broad enough that companies can retain it for as long as they want, except when you explicitly ask them to delete it, in which case they don't have recourse to the business interest clause.
Right. But the problem lies in that, like if I ask them explicitly to delete it, then you don't know whether it has been actually been done.
Yeah, I think there are a bunch of complexities over here. I mean, first problem, for example, we get a lot of data erasure requests, and one of the challenges that we have in fulfilling them is some data we have to retain as part of tax and compliance purpose. You have to keep the records for the 5 or 6 years. So as much as you tell me that go erase my data, I still have to kind of do it for income tax purposes.
Legal requirements are separate.
So that's one. Yeah, so the other is, I think a couple of years ago when we had a data privacy conference, one of the other problems which is very pervasive in practically every organization is that the data is so distributed that nobody knows where this data is. So the first problem for any company to do any kind of, even I suppose like data inventory, is the fact that this data is distributed everywhere. There are spreadsheets lying on on a lot of people's thing, and then also the data is distributed across a lot of divisions in the company. And so one of the issues that kept coming up was, okay, engineering wise, I mean delete the data, but marketing has not been informed that this data has to be deleted, and so the marketing is still sending emails to people. And so that is not necessarily an intentional problem, but it's a problem because the data is
there should be a timeline for the implementation of the bill, and people should be given time to have
so I'm not,
limitations.
Yeah, so I'm not saying that not to have
very quickly we're running out of time, sir.
Yeah, but I'm saying that there exist some of these ground realities where the very fact of the data not being inventoried in the first place itself exists, and so I mean, while you may want to say whatever the letter and spirit of the law, there still do exist these complexities and there will be challenges.
If data has been collected without notice or if it is distributed, enough time should be given for people to sort their thing out. Otherwise, there's no purpose of the, there's no point of having the bill.
Yeah, I mean the bill is on the one hand, the ground realities are on the other.
I'm saying ground reality should be they should be given time, but that doesn't mean they shouldn't do it. Very quickly, because I also have a question about whether there should be a separation between personal and sensitive personal data, because that's an important part which we haven't gone into.
Yeah, just to add to your point, ma'am, that so in section 3A, it says the provisions of this act doesn't apply to offline personal data. So you can, if it is on a spreadsheet.
This point is done. So we want to just move to. Sorry.
One last quick question. Does this bill suggest what is the storage period for data? There's a lot of difference between companies as to what kind of data duration.
Storage limitation is not defined, right? It's not defined.
In fact, it doesn't exist.
Even if it is defined, it will be overruled by some other agency because there is some requirement by some other agencies to keep the data.
So sensitive personal data and personal data, should there be a distinction?
In theory, yes. In practice, again, I feel like let's at least start with some version of a bill which might be simpler, because the problem is businesses will have difficulty really.
Let's take health data, right? Should there be a differential treatment for sensitive personal health data, disease information, blood test results? We know how much data leaks have happened of that kind of information. Should there be greater penalties? Should there be greater restrictions? Shouldn't there be a mechanism for enforcing more accountability on entities that collect that data? For example, today there is deemed consent in data being stored with Practo, and Practo then running marketing campaigns regarding, or not just Practo but other, I'm saying hypothetically a company that's got running a doctor software that takes that data, takes a consent from the doctor for your data and then runs, promotes medicines to you, right? That doesn't seem right.
So here's how I think of it. In the current version of the bill with all its limitations, I think there is need for calling out sensitive personal data. But let's assume for a moment, a thought experiment, that there is fixed those, right? There is no deemed consent or extremely restricted deemed consent. The point I'm making is going down this slope of sensitive data is you're going to keep adding to that list, right? You'll say health data is sensitive for XYZ reason, and then keep adding to it financial data or whatever else. At some point, I do believe that it does become somewhat more difficult to implement. That doesn't mean we don't do it, but I'm saying I would suggest let's take a simpler version of the bill, start implementing it, and then add to that. Once we show that as businesses, as a regulator, as an ecosystem, we have the capability to even implement a simple bill, then we start going into more nuances and technicalities. But that said, if in this bill, this is the amount of protection that is afforded to health data, then that's really worrying.
Anyone else on sensitive distinction?
For instance, if we, as we see the bill right now,
I
it's
think
just
the
one
problem
category.
came from the distinction for transfers.
Correct. There was a localization requirement for Prasanna. So if we were to, distinguish between the data sets and, classify it into multiple different categories and only impose certain restrictions or additional obligations such as the cross-border transfer restrictions on sensitive data or critical data, then that would make it easier. And the second point would be with respect to how the bill as it is today, let sectoral regulators basically step in and fill in the gap, right? For instance, you took the example of health data. So there's another moving piece. We have the APM, the Ayushman Bharat Digital Mission, where you have multiple different databases coming in. So these policies will become enabling policies, for instance, imposing additional obligations with respect to that specific sector. We also see the RBI doing it today.
But the law doesn't create grounds for those obligations to be created.
Right.
Right? Everything is as may be prescribed, but no obligations for more sensitive data.
Right. So what I think the main intention would be is to keep this as the base,
and then allow other sectoral regulators to impose further obligations with respect to data in their
Also, we hope. Okay, there's right back there. That's 2 minutes into mentioning.
Yeah, so not just the difference between business contact information and other personal data.
So the true color.
You could be doing some IT services for a firm, right? And that firm has employees. Those employees have email addresses. If you need to contact them or they need to raise a ticket, right? You need that business contact information, connect with them to solve their problem. And in that process, you're processing business contact information. I have nothing to do with where he stays or what he does.
So I think the role of a data fiduciary is different from the role of a data processor.
Yeah, what I'm trying to say is that you may collect business contact information, right, for delivering certain services.
Okay.
So should that even be covered here? You know, because I think you have the Singapore PDPA does talk about excluding some business contact information. So is that included in this or excluded?
I don't know, man. I get a lot of spam because of there's no regulation on business contact information.
There is. I mean, the GDPR does include that as
not here.
But I'm just saying.
So I don't know. I'm not quite. I think there should be restrictions on sharing of, because at the end of the day, that is also personal information. Right? Sorry, there was a point here. You had a point. There's someone else also here, right?
The mic back, but the thing what she said, there was this fintech conference in Bombay, right? So and I attended that and saw that most of the fintech companies were very happy about data purpose limitations for sensitive financial data, and they wanted the RBI to regulate more and do all of this because that would lend credibility and more people would sign up to their apps. So lots of companies would want that sort of regulation, say maybe even health. But if that happens, even if for credibility reasons, the regulator is imposing these things. So I think that maybe this law doesn't need to make the difference between what is sensitive and what is not, and the sector regulator will do that. And these companies might be more open to following those rules. But if, say, like she was asking, for deemed consent, my child's face has been taken. So is that considered sensitive? Is there some list of, or like my gym membership takes my biometric,
for the
some types of data which we sort of the public naturally understands as sensitive.
So what you can do is you can define categories of sensitive personal data, and you can just say deemed consent does not apply to sensitive personal data. That's a very that's a limited sort of restriction, and then you can leave once you define sensitive personal data, then other regulations that need to be made by sectoral regulators can be made related, but at least give some protection, right? Is my thinking.
Yeah, that's
last one.
Clarify on the sectoral.
Mike, can't hear you.
To clarify on the sectoral regulations, I think the law is very clear on it. If you read section 29, it says it coexists. So the bill is not intended to oversee, supersede any sectoral, localization norms that the RBI has prescribed, or some of the other regulators, because it clearly says it shall be in addition.
Got it.
Right? So I think that bit is they are trying to clarify.
I just wanted to point out on the sensitivity and just basically data taxonomy. I think the legislation also itself calls for a need for defining sensitive personal data and such, because in other sections, such as where they define who shall be a significant data fiduciary, one of the factors that is laid down is the sensitivity of the data, without ever defining what the sensitive data will be. So
just remind me of something else which we didn't discuss, and I really need to close this session up, but I'm going to ask if anyone has any concerns about this. Exemptions for certain other criteria.
yeah, there too they're using like these factors which includes
Define sensitivity of the data, if you have defined sensitivity. I was waiting for you to come into this one, because this applies to what you look at, right?
I think the need to differentiate between sensitive personal data could be looked at harm, because I think what is going to cause harm is probably directly related to, for example, mental health data or certain physical health data. When intersected with other databases has...
Previous versions of the bill, what was the definition there for sensitive personal data? Could you retain that definition?
That is probably the starting point. it has to be more comprehensive, because specific cases, sectoral cases can be considered subsequently, but at least some definition which will pertain to harm should be classified as sensitive personal data, because without that, then leading to specific implementations will not give a common ground, which will lead to kind of variations everywhere. So I think there is a necessity to call out personal sensitive data.
So since I mentioned Truecaller, one additional question, the Truecaller question. Like one of the provisions is for, in public interest, is for deemed consent in prevention of fraud, or prevention and detection of fraud, and that's something which many people use Truecaller for, and that is deemed consent. Like if you have my contact information and personal information in your address book, you can give it to Truecaller, they can process it for prevention, detection of fraud, or at least identifying who's calling you when the numbers are unknown. How do you deal with that use case? It's a useful use case, but also my consent in sharing my number and name and whatever data you might have is not being taken here. How do we deal with that? Some of these use cases seem legitimate, but like, look at, one is not, like, let's look at recovery of debt at some level, fine, but we know how the financial industry has been using personal information to force recovery of debt by threatening to share personal photographs and calling contacts in people's contact lists. They have that data, they're clearly causing harm to people because they want to recover debt. So what about these two? Anyone have any thoughts on these two clauses? A, which is prevention, detection of fraud. G, which is recovery of debt. Any thoughts, anyone?
See, on Truecaller, I think it's a very good example, but I think what's happening is, so let's say they're getting your phone number, right?
So let's not go into what is happening, tell me the data.
So your data is being provided by me, correct? Now, from the perspective of the provider, that information of yours is my information.
It's my deemed consent to you.
Not necessarily deemed consent, but I have stored some information.
Like you took my number from him.
So I have your number.
Yeah.
Right? I have your number. So the fact that I have that information is my information which I am parting with. So they're using that information to.
So we know how they work.
Yeah, so that is the point. The point is they are not really, one could argue that your consent is not required because my consent, because I have that information and I have provided that consent to share it with Truecaller, and as a corollary of that consent.
No, because that notice was never given to me. That consent specifies, that's why the lack of purpose limitation and notice. Like if you go back to the 2018 version of the bill, there were 8 or 10 criteria which need to be included in a notice. Do we have that on the slides? We do, right? With the bill. Yeah, next to this one, right? This is all gone. This is 2018 version of the bill, all gone. So there's no notice.
Specifically, there's a clause on sources of data, other where you're getting data from somebody.
Sources of data collection if personal data is not collected from the data principal, right? So all gone. So if they want permission to share my data with anybody else, I may have given them my data. Correct. I've given it to you.
Once you've given it to me, I have parted with that. That's right. Small.
So you're saying once I've given it to you, you have parted with that.
You have not parted with it. I have parted.
You have parted with that. Correct. But then isn't there an obligation on the data collector to but it's the data is still mine, right?
Yeah, but I have taken it from what I have parted.
So I have no right. Interesting debate. You guys have thoughts on this?
Yeah, I mean,
I'm going to come to Kiran for a solution on this one. Kiran's wondering what are we talking about, right? But let him finish and.
I think you got the drift of what I'm saying. So essentially, there are two fundamental contracts here, right? Where you have shared information with me, right? And you have shared it for whatever purpose. Now, I have your information on my phone and I have shared it with Truecaller. Now, whatever information on my phone, Truecaller has taken my consent to get that information and I've given it. Now, you have a problem with me because by my having consented to Truecaller, they've got your number. So, I think there are two layers of distinction we have to make. The first leg is the problem, not the second leg. Because you giving to me is the problem. And me disclosing it is the problem. But the consent between Truecaller and me is actually as per law. I don't know whether you're following what I'm saying.
No, I'm following what you're saying. I'm trying to find a solution to this problem.
That is the problem.
Because my problem is if I give my doctor my health information for the purpose of serving me, and that doctor gives that information.
That's not the correct example, because there is a different.
The doctor gives it to Practo, and then Practo, I'm just saying Practo, but any other health service, and that health service then uses that to target me with advertising.
I think information in the health sector is completely different. It's differently regulated.
No, but here
Let's just look at the example of the phone number.
In this bill, it is not separate. That's the point.
I understand. I think there are two layers which I mentioned. The consent that I have provided to Truecaller may still pass the muster of law, but the transaction between you and me is not clear. I think that is the missing link.
Okay. Last comment, and then we'll come to Kiran for a solution.
The aspect is that even though Truecaller collected this data from you, the purposes that they use it for should only relate to you and not for targeting the third party. Right?
So they're using it for prevention of fraud. Prevention and detection of fraud, effectively.
So it shouldn't extend in terms of using data.
But I'm not giving them my data to prevent fraud. I haven't given consent to them for processing my data to prevent fraud.
That's exactly my point, and that tells you why it should be limited even though it's coming from you.
You haven't even given consent to him to store your data on his phone.
I may have given my...
Look at the card and dial the number and call you.
Okay.
So I'm saying that if you go to the deemed consent and
there are layers below layers
of consent, it's never ending.
No. So I want to ask a question that kind of makes it a little difficult. Individual who's being profiled had no say in the matter, versus a Wikipedia profile of a person where Wikipedia explicitly prohibits the person from being involved in the profile.
Oh God,
Look, it's all aggregation of other sources, right? Truecaller is aggregating from various individuals through explicit consent from the individual, except the data principal. Exactly the same thing happens on Wikipedia when you have a profile of someone where Wikipedia rule explicitly prohibits the principal from being involved in anything that is said on their profile page. So it's slightly, it's not black and white in this case. Honestly, I don't know what to do here.
We came for a solution, open another whole new model display.
So can Truecaller not exist with any of this? Exactly. So we are talking about it as if it has to exist and we should find a way in the law for it to exist. Suppose it shouldn't exist.
Let's face it, a lot of people rely on it for prevention of spam and fraud.
Yeah, but even if I give my friend my number and I'm okay with her storing it, but I am taken in Truecaller, I don't know what is happening in the background, but I appear on some people's phone as a marketing agent, although I'm a journalist. So I have no control over how I am represented either, even if I'm okay with my number being shared. So
I first asked this Truecaller question in 2016. I still don't have an answer.
I think there you can exercise your right to correction.
Right to correction, right to erasure. By the way, they allow the right to erasure. I'm not there because I put my number there in the right to erasure. So anyone can do that. But again, deemed consent for that processing developed. But anyway, we could go on. Is it for this particular session?
You talk about deemed consent, right? The perspective of the lay consumer like me who doesn't have another, who doesn't sign up for ADA, wherever I can avoid, I don't fill up forms. Because I'm concerned about my data security.
Right.
I'm a layman, I don't have all
I got that. I'm sorry, we need to close on the
I'm closing by asking you that perspective of all these laws will change about the bill itself. Once the layman like me, an ordinary consumer, understands what is the value of my data. then all the perspectives and all the stuff that you
Okay, not related to the section.
No,
So I'm going to
Closing. I'm sorry, sir. Closing. Just on the two-color point, one last thing.
Two-color point, you got me there.
Section 4 of the bill, which speaks about applicability, says that Part A says that the bill is only applicable to processing where the data is collected from the data principal. If you can go to that point. It may be poor drafting, but that's what the law says.
I don't think I have
that up. Applicability and exclusion. The provisions of the Act shall apply to the processing of digital personal data within the territory of India where A. Such personal data is collected from data principals online. So, our assumption is that if you collect it from elsewhere, or if you infer the data.
You can collect it from a data principal, but then you can collect data from a data principal. That data could be someone else's data also. No?
Correct, but if there's anything other than that, if there is any form of either inference that's drawn on that data, or where you are coming to your own conclusion about the individual, it may still be personally identifiable information, but let's say I collect from you your date of birth, and from that I infer your age, your star sign, your XYZ. All of that essentially still falls outside the purview of the Act, because the entire Act, Section 4 says that the entire Act is not will only apply to XYZ, and if it doesn't come within that, I will say
this session will never end, man. Sorry, we're 45 minutes late. Okay.
Just a comment on that, but by that logic, suppose I just started randomly hitting numbers, then saying that without the person's content, then we can't really extend inference, that Section 4 to inference.
Mobile number wasn't personal data in any case.
It was, but
no, it wasn't.
the point that they said that
it wasn't. Mobile number wasn't defined as personal data in the previous versions of the bill.
in the previous version.
Yeah, and it's not here either, technically. No.
Yeah.
Okay, we're going to close. Intense and we went way over time. We're going to have to cut other sessions a bit tight now. This was amongst the most contentious sessions in Delhi, but
available for children.
Actually, super fast.
Okay, super fast. We go super fast. Privacy safeguards available for children in the new data protection bill. So this is what the bill says. Companies have to obtain verifiable parental consent before processing any sort of personal data. Two important things to note here. One is that how this verifiable parental consent will be obtained is not clear, because the person giving consent on a mobile phone or a laptop, how will you identify that person is actually the parent and not someone else? This is one of the questions raised here. And it's also important to note that child is anyone below 18 years of age. So even a 17-year-old might need parental consent for joining a dating app or joining a social media company. So these are the kind of questions that this clause raises. The bill also states that data fiduciaries shall not undertake any tracking, behavior monitoring of children, targeted advertisements directed at children. So this will impact businesses, it could impact career counseling services, and any sort of service that is being directed towards children. The tracking ban is actually it's a blanket ban until exemptions are prescribed by the central government. So what businesses and what purposes will be exempted from tracking will be prescribed later. The bill also states that any sort of processing of data that is likely to cause harm to a child is not allowed, as may be prescribed. As it was discussed earlier, the definition of harm has been trimmed down. 2021 version of the bill had the following things: the definition of harm, but all these things have now been reduced. Removed. These include things like blackmail and extortion, discriminatory treatment, psychological manipulation. All these were included in the 2021 bill's definition of harm. They are no longer present in the new version. So these we have already gone through. What has changed? The following provisions have also been removed from the bill. One, as compared to the 2021 version of the bill. So one is that one clause states that every data fiduciary shall process data in a way that protects the rights of the child. This has now been removed. Another thing that has been removed is the manner of verification. There were certain things which were prescribed in how verification has to be done, like volume of personal data, proportion of personal data likely to be that of child. So all these have now been removed. The manner of verification is not mentioned. We don't know how this will be carried on. Yeah, so now we'll move on to the questions.
Not questions. Vaneesha, your initial remarks.
Thank you for having me here. It's great to be here. I know we had a long last session, and I would love for this session to be slightly quicker and also more interactive. So I've prepared very brief comments, and happy to hear your thoughts and respond. And I'm assuming that everything that has been put up here is already something that everyone has thought about. So I'll keep this very brief. One thing that stands out to me on the aspect of children's data, and given that the 2022 bill has been made so brief and so small, it has me wondering what are the additional things that it actually provides in addition to what we already have under the SPDI rules, which have been widely criticized as being next to nothing. And I think maybe a discussion on children's data is one of those things, one of the SPDI plus.
Sorry, what is SPDI?
SPDI is the Sensitive Personal Data Rules, which is under the IT Act, that currently occupy the space that we generally talk about when we talk about, are there any rules at all around processing of personal data or taking consent and things like that. So there's nothing, there was a gap in legislation. The thing that we lawyers sort of run to is this very brief set of 8 rules called the SPDI rules or the privacy rules that fall actually under a very narrow scope under the IT Act, which is the Information Technology Act. And coming back to, just sort of grounding us all back into the history of this bill, it came out of the Aadhaar judgment, the Puttaswamy 9-judge bench privacy decision, which sort of reiterated that privacy is a fundamental right. However, it's not an absolute right. There are certain reasonable restrictions. The reasonable restrictions have to happen on 3 grounds. The first is the existence of a law. So really when we're talking about this bill, we're talking about that law, which will circumscribe the subject to other tests like proportionality, the extent to which the right to privacy can really be eaten into. Coming to children's data, I'd like to focus on these 3 aspects. One of parental consent, where I think I have the maximum thoughts. The other is that of age verification, which is noticeably absent in the 2022 version of the bill. And the third is how we sort of read any policy on governing children's data across the board with this bill and with other laws such as the intermediary rules, etc. Where you talk about an intermediary's duty to take down certain content that may be, in the lines of CSAM, which is child sexual abuse material, etc. So very briefly on parental consent, a couple of things were already pointed out, like how do you figure out who's actually giving the consent? How do you know that it's actually the parent of the child? So some arguments have been made that means you have to collect even more data. You might have to implement facial recognition or other forms of data to actually identify both the individual, who's the child, and the parent, as well as the relationship between them. So that, just to keep that in mind, and how that actually increases the amount of data being collected as opposed to minimizing data. Also, as is pointed out in the previous session, not every parent need be, or lawful guardian need be someone who's acting in the best interest of the child. And that's again a phrase that's absent from this version of the bill, which was there before, which is advancing the interests of the child or acting in the best interest of the child. So what stood out to me is that the child's agency is absent here. The child doesn't have the right to specify which parent, whether a lawful guardian or someone else, would be sort of taking decisions on their behalf or supplying consent on their behalf. The other thing that's absent in that line is even where we say that a parent or a lawful guardian has given consent on behalf of a child who's under 18 years of age, is there fresh consent being taken from that child when they turn 18 years old? So there's been a lot of data that's been collected and processed. At the very least, I would hope that there would be some amount of information as to this is the consent that has been provided on your behalf, and do you agree, do you want to continue, do you want to withdraw? there's complete silence on that aspect. The other thing that we talk about is a graded approach. I mean, we mentioned that a child is still defined as under 18. There's been a lot of talk about reducing that age to 13 or 16. In light of a couple of things, one is you can't treat a toddler the same as a teenager. The other is, just the reality of how people operate on the internet. People are accessing the internet from the age of 1 and 2. And by the time you're in your teens, you're pretty much self-sufficient. It also is true that there is a generational gap in terms of there are still a lot of parents who may not be from the educated urban sort of section of society, who may not be literate, who may not be internet literate, and may not be able to really monitor and survey their kids. And having used that word, that segues into the issue of parental surveillance to some extent. And like again was pointed out, you don't want teens to have to necessarily take consent for every kind of activity that they may be indulging in, such as accessing different streams of educational content, or getting into dating profiles, or watching certain games, or there's a certain level of autonomy. So one thought that I had is to apply a graded approach there, where either you follow the GDPR line or other laws where you define a child differently at lower ages, which argument seems to have failed because it's been made multiple times. But the other is to have a graded approach and say, okay, from a certain toddler ages, you have somebody in authority taking decisions for you. But maybe later in your teens, at the very least, you're also signing off. It's not just your parent that's signing off, but also the child. Which again ties back to the idea of informational privacy, because when we talk about the fundamental right, those are applicable to individuals. Those are not applicable just to adults. And to that extent, I think it's very important across the board to inculcate the idea of consent in children from the get-go for everything. And that largely applies to the information that they put out online, the identities they create for themselves online, and the ways that they interact online, because that's increasingly becoming an extension of our lived realities and personalities. And I'll just leave with a short comment, which is that at least when it comes to children's data and privacy of children, there's always, it kind of highlights that constant debate between freedom of expression on the one hand and protection on the other hand, right? So you're never going to have complete freedom, you never should have complete protection. And I think that's, I don't think there are any definitive right answers. There's always scope to use, misuse, apply discretion. So with that, I'll leave it open to thoughts and comments.
So I have a two-caller question for that I've had it for a long time for the previous one. I have an Alexa question here. Google, so she says Google's been trying to say, okay, Google to the Google speaker for a while. How does verifiable consent work there? In voice, how does verifiable consent work in voice? Any thoughts? How would that work? How do you verify consent? What's the mechanism for verification? How do you know whether the person who's verifying for a child is actually related to the child? Any thoughts on how that will work?
I think that's one of my opening comments as well, because you have to identify the identity of the child as well as the parent, as well as the relationship between them. That's 3 levels of identification that you need to do. Also, what's the point behind it, right? So even when it comes to age verification, for example, if you want me to verify that I'm 18 or 16, does that take me to a different page? Is it just to say that I'm 14 or I'm 25? But are you providing me with a different mode, or like a safe mode or a child-friendly mode of accessing the same information?
Anyone on the technical side want to talk about how this might work? Zainab, any thoughts on it?
No, I don't. That's it.
One of the methods I have seen is asking for payment verification. And this is American websites. When they want you to prove that you're not a child, you are required to provide a credit card number that's valid. and that's all they do. They just check that it's a valid number, they don't charge it. It's a very dangerous thing to do because you don't know when they'll charge it because, having cards. But that's a mechanism that I've seen being used. Now, one of the other mechanisms is to simply ask for the year of birth. And that's slightly interesting because, it assumes that the user has not lied, but it also means you're not collecting any actually relevant personal data. You're not collecting an actual birth rate. You're just using the year to say, okay, before this year it's fine, after this year it's not fine.
But people will lie.
Yes, but how does it get around lying is not an answer thing. But on this Google thing, Google does have child accounts. Now they don't collect any personal information, or rather they don't collect any ID. So they don't do any ID check on the account. But what they do is assign responsibility and say that if I declare myself as a parent and I'm creating an account for my child, and this is the child's birth rate, then they let me extend that to the Google speaker. And in the Google speaker, I can set up voice match. And so if the speaker knows when it's my child asking a question. Now, part of what happens here is that they have actually broken it in the other direction. I cannot give consent on behalf of my child.
Even when a child is saying, okay, Google, whatever, this still data is being collected, is being processed, and the decision not to act on that is still an act of processing technically, right?
And so it takes my consent. It takes my consent to set up voice match to recognize my child and then limit what the child is allowed to do. But it actually works the other way. I cannot give consent because it's broken. The implementation is broken. For instance, YouTube Music used to have an age limit of 16 until a couple of months ago. And so whenever my child would ask me to play a song, it would say you're not authorized. And for her, Google is the enemy now because it always says you're not allowed to play music. And so she has to ask me and say, please ask Google to play this song. They fortunately fixed it last month. But she's now 8 and she has a history of thinking of Google as this unhelpful thing.
So I work with clients, technical clients who implement age verification for children. And there are sophisticated mechanisms that tackle some of what you mentioned, which is if a child is registering themselves and or if an account is created on the platform and age verification is required, then they require the parent's presence in a video call with a back office team. And the video call is not recorded or maybe only recorded to the extent that age verification purpose for legal compliance. And then the child's account is enabled. Another is payment mode is disabled unless an adult has verified the account. And third is they actually have different versions of the same game. So you only get a default version that is age appropriate for everyone unless you have actually shown your age to be above 13 or above 16.
How do they determine the relationship between an adult and a child?
So I believe under US law, if an adult is present, it doesn't have to be a guardian or a parent just for that session. But if the account is to be validated permanently for a particular age, then the parent has to upload identification information.
How do you know that that is the child's parent?
So they have to upload identification information for both, exactly what she said. It's more information that's collected.
Again, it's so for both, but how do you establish a relationship? For example, it could be stolen data.
But it's using public databases. Government databases are allowed.
But it could be using stolen data. How do you have verifiable consent?
By a live video recording of the person. That is providing the consent. So you are matching the live video recording against an ID proof that is in front of you as a human agent. That's what they are doing.
So what you're trying to say is the solution for this is to basically do Aadhaar authentication for everyone in India who's using the internet.
I'm not saying that's the solution. I'm saying that's one solution that has emerged in other countries where this kind of law has existed.
Do we have any other solutions?
The other solution is the default, right? The default, which is age appropriate for everyone, and you restrict the game experience.
Not necessarily just talking about games. I mean, even to access a website, even to access Google search, for example, even to use an Alexa, for example. What this is, that there has to be verifiable consent for everyone and everything.
I would argue the other direction is if as a parent, as an adult of any sort in a household, if you are providing a device of any kind, whether it's a voice interface or a text interface or any other, the responsibility ultimately does fall on the individual. The law cannot protect against malicious or incompetent behavior by responsible adults in a household. I don't think we should take it to that extent. I mean, if the child is asking inappropriate questions to Alexa, Alexa has mechanisms to detect a child's voice, at least, at a minimum, and protect. It's not Alexa's responsibility.
Correct, but the phrase there is verifiable consent, right? So it will have to be verified in some shape and form. It will have to be verified against something.
Absolutely, and I don't know of a way around what you mentioned, which is...
I actually did have a thought on that, which is sort of a midway between what we had in earlier versions of the bill, where there was a category called guardian data fiduciary that was created. A guardian data fiduciary was essentially a service or a platform that was sort of targeting their services at children, and these additional obligations on processing children's data was made applicable only to guardian data fiduciaries. And in later versions of the bill, starting in 2021, I believe, is when it was taken away, and these sort of additional obligations were made applicable to all data fiduciaries as long as they were processing children's data. I actually think a great midway would work, where you make things like verifiable parental consent, which is a very high threshold, applicable only to entities that are sort of targeting children.
So we had a conversation in Privacy Now in September with Dr. Surya Livingston, who's done some of the most impactful research on children's uses of the internet. And we were debating some of these issues, and suddenly it hit me. We were almost talking past each other, and everyone else in the panel, she were talking past each other, because of a fundamental difference in how the UK approaches protection of children and how India approaches it. In India, we start with saying everything is banned for children unless there is verifiable parental consent. In the UK, everything is accessible to children except for certain identified types which will require verified parental consent. So they start with saying access is important, and then protection is when it's necessary. We start with access will only be allowed where liability can be transferred to a parent. So we start with prevention, they start with access to the internet. Fundamental difference in how they approach it. Ties in with your point about guardian data fiduciaries.
Absolutely, because I think there has to be some level of nuance and gradation, and I agree completely. Why should children not be given the whole idea of the internet was freedom of information, right? Why should I be denied to children?
Most of us around here have had access to the internet at the age of 13, 14, 15, 16, 17. And the way we use the internet changes as we grow older, even and drastically in that age group. What point? Like, what you're saying is you're going to basically cut off an entire generation until they come of a particular race, because remember, the liability is going to be on the data fiduciary, not on the parent here, right?
Absolutely.
So effectively, if a child has to use WhatsApp, the parents will have to give Aadhaar authentication and give more data to Facebook to be able to allow a child to use WhatsApp. Is the way it right now. So how do we solve this? Any thoughts, solutions, questions?
Did we hear more? I think that it's important. So one is, I understand that this is a digital data protection bill and we can only talk about online data, but at least when it comes to protecting children broadly, there you kind of keep sight of, and I'm just drawing that parallel to say in the offline world, there are certain things we keep in mind when we talk about protecting children, right? Which extends a lot into the online world. Stuff like grooming of children and, so sexual harassment of children or abuse, or that's the kind of thing we want to protect against, and not controlling what children can or cannot access. I think that is one of the primary differences to be made. It's not at the expense of the agency of a child.
Should there be a prevention on profiling of children, on behavioral targeting of children?
Again, I'm hoping that, with that very scary, broadly worded exception clause, and subclause 4, which says for certain purposes, 1 and 3 will not apply. Where the, subclause 3, which is about behavioral monitoring and target tracking, will not apply. I'm hoping that's where we will carve out these exceptions where it's for the welfare of the child and for preventing exploitation of the child is when
that's been removed, right? The UK also has a thing in the best interest of the child, but here all those that exceptions been removed. Right?
I'm saying under the subclause 4, when you come across, when you talk about the purposes for which 1 and 3 will not apply, those purposes should be linked to protecting the child against exploitation, and that's where tracking should be allowed. Sometimes where monitoring the behavior of a child may be allowed in the interest of preventing exploitation of the child. So,
anyone?
Question?
Any thoughts, any questions? I think
I was just going to say
first come first served.
So I was just going to say that age verification, if it's not required to be targeted individually, has also been done based on online MAT tests like CAPTCHAs, right? I mean, we are talking about CAPTCHAs only for verifying a human, but companies have come up with technology like MAT tests that prove that you're finished 7th grade. Now in India, that's going to be an entirely different issue. But at a minimum, if you can solve a problem of a particular age group, and there are it removes the individual private information from the equation, just verifying for that session that the child is of a particular age. Now, obviously, the answer could be fed in by somebody along the other.
I think there are different levels of mathematical ability.
I understand, but we are not going to solve this. But what I'm referring to is the minimum information in the other clause. If the only recourse you have right now is the parent to link their Aadhaar ID to the child's Aadhaar ID and so on, whereas if there is a simple purpose like listening to music or whatever the level of harm, perceived potential harm is lower, you could have lower verifiable standards, whether it's a math test, whether it's an emotional test or some other kind of test. The same test may not work for every child, but there is technology available.
Yeah, taking that further, I guess to require parental consent or sign off only when it's a question of accessing sensitive personal data, for example, financial information or health data of a child.
So you're in the block that says sensitive personal data should be defined in the bill.
Okay. I think there's value to defining at least to some extent. Yeah.
Right now, the way the law is, what is its philosophy about how children's data should be protected? Is it sounds paternalist, but it's also not saying that you can't analyze the data or process it. So what is its philosophy? And I understand the problems, but overall, what is it looking?
To be honest, I think it's largely a carry forward exercise that's been done over the last 5 years. It just sort of tries to set up, it is protectionist, and it tries to set a higher threshold for processing data. So I'm collecting tons of volumes of data. If I identify that some of that data relates to children, then I have some additional obligations towards that data. I think probably that's the approach.
I mean, just in terms of going back to the discussion in the previous session, how does Section 10 interact with the deemed consent provision? I mean, it's all good for us to say that we want these additional protections and related to the rights of children. But when we have a broad-based deemed consent provision, the question is, won't a lot of this consent be deemed?
I agree with you completely. When Nikhil was talking about the child saying doodle, hello doodle, I was like, deemed consent. Yeah, but a bit more than the drafters probably did. But I don't think that they really focused on this interaction, and I think they only imagined deemed consent as applying to adults.
Because I mean, if you think of rights of children, and then you're going to incorporate a very complicated mechanism, which is very different from the way you treat personal data of adults or non-children. On the other hand, you can't do without it. So
I think the way that this is playing out is almost like you strip the child of all agency and you say you don't have a voice and somebody else is going to speak for you. Any sort of parental or lawful guardian actions as more as a co-signing off rather than replacing.
How would that work?
I I would say, I mean, where you stick the sign of I accept button or whatever, you get two people to do that. One is the child and one is the parent. It's a very broad idea, but stemming from...
Really smart children would sign off on both, right?
Yeah, because at least there's some level of participation.
No, really smart children will tick both boxes.
It doesn't,
Most children above the age of 13 would tick both boxes. It doesn't work.
They would, but it's not just a ticking off. I just mean, it doesn't solve for, the issues of data collection and things like that, but it solves for the problem of non-participation by the child in their access to the internet.
Mike,
I think she's had a question for a while.
For a while, yes.
I would say actually moves quite well from your point, right? What we're saying with something like this, where we set a sort of absolute threshold at 18 for a child, is to say that up until this point you have no agency, but as soon as you turn 18, you now magically have the capacity to consent to types of data collection, processing, sharing, and so on and so forth. And so I wonder why we don't sort of already have some level of legal consciousness around the different ages at which you should know the consequences of your actions, given that there are judicial precedents, like the Juvenile Justice Act. Right? Even globally with the GDPR, you have the freedom to determine that age between 13 and 16, and countries take advantage of that. There are many countries where it's 14, where it's 15, where it's even 13. So I just wonder why...
You can work, children above the age of 14 can work in child shops in certain circumstances.
Exactly.
Except mining and stuff, they can work.
So
they have that agency to earn a living, but not to... not to browse YouTube.
To respond to your doubt, my sense is that the reason it's been fixed at 18 is it carries forward from the contract law that we have.
But then that's, if you're working somewhere, that's also a contract effectively, right?
I agree. I'm just saying that's sort of the debate that's been had on the data protection bill, where they link back to the Indian Majority Act, and because a lot of online concept, or you open a website or whatever, it's seen in that click-crack contract framework. But that doesn't really apply when you make it so absolute across the board, without the nuance of like I said, where you ask for certain higher thresholds only where a lot of
Sorry, if I could just complete that, acknowledge that different ages, even under 18, have different relationships with the way their data is being used, processed, shared. The kinds of harms, interventions you could have become, again, immediately blanket. There's no sort of understanding of how, okay, if you're 14, maybe you spend more time on the gaming sort of sites. How do harms specifically hurt your interests there? Or if you're a little older and your location data is more freely shared because you can travel on your own in cabs or something. Like these specific sort of relationships don't come in. I mean, this is anyway very sparse and nugatory, but the point being that this level of lack of attention around children is what makes it particularly alarming. Thank you so much.
Okay, so we're going to try and limit to very short points and very quick sort of interventions because we got to move to lunch.
Yes, just very inferences, particularly maybe the education sector based on data that we collect for children. Specifically, number one, have you seen any instances of schools, colleges, tech companies making inferences on the academic capability or success of the student in the future?
Right, so the last part of what they do is exactly that, right? They draw inferences, they recommend courses, they try and sell courses. That's all that will be allowed under this bill.
So the follow-up question would that be, would you think the term targeted advertising accurately or completely covers the harms that could be caused, or should we add a specific, or should it be recommended to add a specific phrase that a data fiduciary cannot also undertake inferences?
So in terms, let me just jump in on this one.
Sure.
Targeted advertising, so one is profiling, and so for example, profiling could be for the purpose of identifying groomers, right? Because someone can create an account as a child and then based on behavioral patterns, there are instances where platforms determine whether that person's actually a child or a groomer, and then they can block that account. So that's one profiling where that works. The other example where targeted advertising comes in is where let's say you are determining the weaknesses of a child when they're doing courses, even on Khan Academy, etc. and then they will pop up courses that they can do. Now you can say that's not advertising, but even tech companies build profiles and on the basis of that recommend certain paid courses, so that would be targeted advertising, which is off. So perhaps the inclusion of a clause on in the best interests of the child would be the right way to go over here, because that creates an exception, and then it creates a liability if someone wants to go and challenge that this was not in the best interest of the child, and the adjudicating entity can determine, or the court can eventually determine whether it was or not. So that's the limitation that might come in. But not profiling is a bad idea in that sense, as long as you limit it by purpose. But if you remember the last session, the entire notice section has been thrown away. So no notice. Sorry, I sort of been thinking about this one for a while.
No, absolutely, I agree with you. And overall, I mean, I had, if there are really important to create a sort of graded understanding, even if we keep child broadly defined as anyone under the age of 18 years, to create sub-gradations amongst that. So maybe toddlers on the one hand, primary school children, and then teenagers. And this is not, this is not something new, this is not something we've not seen in other laws. Just talking about, because we're talking about child rights, we look at the Juvenile Justice Act and the POCSO Act. There are so many cases relating to young adults in the age bracket of 16 to 18 years of age, whose consent really stands on a different threshold than younger children.
So people who are exploring their identity, for example, it's a critical aspect of being anonymous and being able to explore their identity online.
And make decisions about their married life even, because
find support groups
also.
Also find support groups, people who belong to the LGBTQI community. They need that anonymous exploration to figure things out. You've had your hand up for a while.
So I agree that we broadly recognize me, but I think the law as a policy choice said that provided that you as a parent are not abusing your child and providing them education, food and so on, that we respect the privacy of your household, we let you make parenting choices. So I think a key method of verification often is whether you have a phone number. So if you're signing up for WhatsApp, you need to verify your phone number. But that's a parental choice of whether you're giving a phone to your child or you're giving a SIM card to them, right? So I think that's a fairly middle of the road approach, wherein we respect parental autonomy while also giving the child some choice over themselves. So it's just a counterpoint to this idea that we should give children complete control over their online browsing experience and so on.
I have a question related to that. SIM card to a child. So if a child has a device and a SIM card, and you can only register a number as an adult, and you provide your details, and later you might give your number or your device to a child, would that effectively be in violation of this law, because in terms of duties you're providing false information regarding the ownership of that SIM card or that usage of that SIM card, right? So you open a can of worms over here, especially with shared usage with a child. Just random thought based on when you said SIM card, I thought of that. By the way, SIM card also now requires, we found this out, we did a discussion on the telecom bill in Delhi in November, and we found this out that there's a system called Astra. So when you buy a new SIM card today, they do they do a video KYC. That video KYC goes to the backend to DOT for facial recognition, and the rationale is that you're not allowed to have more than 8 SIM cards as an individual. So for spam and scam prevention, they're collecting facial information. Anyway, sorry, question. You've been waiting for a while.
Yeah.
Sorry.
So my question was, let's say that dating apps were made accessible to teenagers, given the fact that it's not that teenagers don't date, they just are not allowed to be on dating apps. So should there be a requirement for parental consent, given the fact that that's usually the age where children are exploring their sexuality, so they could very well, it is required for that, it could actually be a little deleterious for the child in question. And secondly, let's say that it is opened up to children, should there be a limitation on the age group that they are allowed to date in? For example, let's say a 16-year-old cannot keep their age group up till, let's say, 25 to 30, because they could very well be very prone to sexual exploitation, grooming, etc.
What do you think?
I think one way, like parental consent shouldn't be required. However, there should be a limitation on the age group thing. But then again, there could be adults, older adults who, pretend to be like much younger.
Yeah, there are all these complications, but I don't know that it's necessarily even being discussed to that level in this bill, and I'm definitely missing here, and that's required not just in the data protection bill but across the board, based on lived realities and social realities in India today. Do we have time?
We don't. This slide here, what's been removed from the 2021 bill. What are the implications of harms to a child being, the definition of what are harms being removed, implications?
And it's crazy to me because the list of harms that are removed, putting them together literally talks about grooming to me. When a child is being groomed online, these are the harms that they're subject to, and it's wild that that's what's been taken away.
And also, as maybe described, is missing from the definition of harms, so it seems quite definite what the government has written.
So this should go back, is what you're saying?
Yeah.
Okay. Someone had a hand up here. Last two comments, and then Vaneesha will come back to you for recommendations.
Right to withdraw the consent by the child for the consent that the parent has already provided.
Wow.
That's something that I did address in my opening remarks, which is. Can you hear me? Yeah. When I turn 18. What is the list of like 500 things that my parent has or has not provided consent on my behalf for? Yeah, so there is an information gap is what I'm saying. If I've been taken out of the equation as a child and my guardian is providing consent on my behalf, says Vaneesha can do these things and cannot do these things, at the very least I need to know that. The question of providing fresh consent or withdrawing consent comes after that. So I agree with you, and I think that's something that definitely needs to, and which is why my one thought that I had is to have a participatory approach, even if you need to have parental oversight. Let's call it an oversight, let's call it a sign-off, but let's not put the child out of the equation.
Yeah, the last one here.
Yeah, I just had a question in dating apps or just like browse on the internet, and I wanted to understand whether the law is limiting a question of access or processing. Because is it saying that children will now not be able to access YouTube without parental consent? Is it saying that they won't be able to access the dating profile that they would otherwise? Or is it saying that once they access it, the processing should be limited in the sense that it is data relating to a child, and as long as you don't have parental consent relating to it, you can't process it? And I just want to understand whether it's even like, is it a matter of technicality that if you can't process data at all, you're practically limiting access, or is it that access is entirely limited or not?
Does anyone have a definition of the word processing? Because I frankly can't separate access from processing when it comes to digital. So the act of access is always going to lead to processing.
Like an example that I can think of, which might not be entirely true technically, is that, for example, I go on to...
Can I give you a small little example?
Yeah.
Processing also means storage.
Correct.
So when, let's say, if let's say Sarvesh is a child and he's using YouTube and YouTube is not allowed to process the data, how does he get access to anything without the data being stored? You cannot separate access from processing by definition on the internet.
Unless, I'm browsing without signing in, without putting any kind of like requirements on, okay, now that I have looked at this video, this is my history.
Signing in doesn't matter.
So yeah.
Because you can, so either that or you prevent browsing without signing in because you need verifiable parental consent, because everything is going to lead to storage, everything is going to lead to
cookies, everything's going to lead to profiling.
Yeah, so as long as you're like entirely eliminating the option of browsing without signing in.
So to go back to the first clause, verifiable parental consent means in order to identify who's a parent or who's the child, everyone will have to be verified. Because otherwise you'll end up processing the data of a child without having verified it.
So just to respond very quickly, I think the way to look at it is that the prescription of this clause is on the data fiduciary and not on the child or the parent. So it's not a question of can I access
on whether I'm able to access these services at all being shifted towards the data fiduciary side, then the question arises, why have you removed the statement of in the best interests of children? Because in effect that can really like prevent a lot of the harms that we're otherwise trying to like sort of account for by the right.
So we'll have to close. Sorry.
Just a point which is similar to what you mentioned. You know, so say I'm a corporate and I have a career portal page, not for children, but I'm not collecting age of anyone who applies on my career portal, right? So what if a child, 17-year-old, goes in, puts his or her details in that form, right? I do not know at the back end that it's a child, and so am I supposed to then have, like you said, verifiable age for everyone across?
That's what was my reading.
And that's the conversation around age verification as opposed to parental consent. And
yes, so it effectively means that I have to verify everyone's age, though I don't need it.
That's everything on the internet.
It's designed to be digital by design, and it's also designed to be independent till you get that data. And as I claimed, when the state or central government says, please act on this, or if a court directs it to. And I think this, if we are really looking at as may be prescribed like a credit provision, it perhaps appears the most when we're looking at composition and how the board will be selected. We really don't know anything about it. All of it is being dedicated to future rules and legislation as well. All we do know is that the chief executive managing the board will essentially be appointed by the centre, again bringing into question the independence of the board itself. Many of the powers that are assigned to the board are similar to what's already there in previous versions of the bill, so I'm not actually going to go into depth with all of them. The one that's new and interesting is actually voluntary undertakings, and it comes from Singapore as well, which is where we've seen this mentioned in its own data protection law in clarifications released in October, where they say that the board may accept a voluntary undertaking from a data controller, data fiduciary to essentially stop a complaint in its tracks, and the data controller will essentially continue remedial measures on its own steam. And that's something new and interesting, and we can get into that later as well. How is this different from the Data Protection Authority of India that was mentioned in 3 previous iterations? I think Alok has also spoken on this at previous media Rama events. The DPA had vast responsibilities. I'm just going through, a smorgasbord of them, but they really were like up to 20 different bullet points going on in the drafts, and that's really being narrowed in this case. We just have the adjudicatory one as the primary one. There's also a sort of revised understanding of what grievance redressal really means. Yes, the board is opposing penalties, but are people being awarded the right to seek compensation? So when we're thinking about justice under data protection laws, I think that's an important thing to consider as well. And finally, the previous bill was criticized on various fronts for being bureaucratic, for having lots of different prescriptions, for having too many government secretaries. You can't even do that in this case because you have no idea who's actually going to be on the board. So I think it's sort of really all left up to that, and I think Alok has some interesting comments on that as well. So that's just a general overview of the board, and we'll kind of go through these discussion questions as well while we're having the Q&A as well.
Alok?
Yep, over to you.
Sure.
Thanks, Nikhil. Thanks, Aarti. At least given you a good overview of what the bill contains and also what it does not contain. I was just having this conversation over lunch that I have the easiest task. I can just say, well, there's supposed to be a data protection board, but we'll find out what it looks like when the government lets us know. But I think there are some serious concerns here. And these are concerns worth addressing, worth discussing. And while I sort of know that we all kind of want to sort of keep this at a level of
the logic, the law and policy, let me start with an emotional note a little bit. Because for me, when I first read the draft of this bill, it was disheartening. My first instant reaction was not what is right or wrong about it, but my sense was someone doesn't care enough to give us a proper data protection bill. And to me, that was additionally disheartening. Because one, a data protection bill is for us at the end of the day as citizens of India. Companies may have certain more obligations, foreign companies may have certain concerns, how to comply, how it will benefit, all of it is all very important aspects of it. But the origin of this is from the Supreme Court affirming that citizens of India have a fundamental right to privacy. And this right to privacy needs to be protected and enshrined through proper legislation, which provides an enforcement mechanism, which outlines the rights, which provides remedies and so on. And for all their flaws, and full disclosure, we worked with the PhD Krishna committee to produce the first draft. Whatever criticisms, whatever debates we had, I still felt that those versions of the bill were something rather than another. Right? We could say that there was too much exemption given to the government in the last version which the Joint Parliamentary Committee put out. We could say that the DPA has been overburdened with too many things in the first few versions and needed to be re-examined. We could say that right to be forgotten should be there. We could say that government surveillance is not properly accounted for in this bill. All of those were valid criticisms, and all the bills at least provided us sufficient basis to have these debates, to have these discussions, to push for certain change, to push for certain reform. When we're left in a situation where we have a very bare bones bill with everything will be determined at some point of time in the future, it cuts off our ability to have this discussion. And I find that even as I try to discuss this within my peer group, within people in the sector, there's a sense of, why bother, man? They clearly know what they want to do. Well, what are we going to do? So that is the emotional space that I wanted to sort of start from. But to get to the legal aspect of it, two basic concepts I think are worth outlining here before we get into the meat of the bill itself. One is something that all law students learn, I think, in their first year, first semester, maybe first class, and we are all introduced to our first big Latin maxim, is Ubitus ibi remedium, which is where there is a right, there is a remedy. And it is something very fundamental and core to how the law functions. When the law gives you a right, it has to give you a remedy. You cannot say there is a right here, but there is no way for you to remedy, in which case it is not really a right at all. So, keeping that in mind, let's sort of understand that the fundamental right to privacy is not just enforced in terms of like going to court, but is supposed to have other remedies as well. When this bill creates certain rights, it says that it has to say that it's supposed to be enforced in a certain way. How does this bill envisage that we enforce our rights? It expects us to go to the Data Protection Board. One clause which was not mentioned in the presentation, but that I'd like to start with, which is the key to understanding what is the fundamental problem with the Data Protection Board, is clause 22, subclause 3, right? Which says, no civil court shall have the jurisdiction to entertain any suit or take any action in respect of any matter, I hope I'm counting the any's, under the provisions of this Act, and no injunction shall be granted by any court or other authority in respect of any action taken under the provisions of this Act. That's about 5 any's in this one statement. Yeah, that's the clause. It sort of begs the question, why? Because, not that this is completely alien to the law, let me clarify, there are a lot of legislations which house the jurisdiction of the civil court. They are available in a lot of legislation. It's not fundamentally unacceptable or unconstitutional. The Supreme Court has upheld it in certain instances. But what the Supreme Court expects is that when you are ousting the jurisdiction of the civil court, you provide an equally efficacious alternate remedy. Key term here is efficacious. It means it should be almost as good or just as good, if not better, hopefully, than the remedy that you have available in the civil court. Right? And this is an important point to keep in mind, because effectively, if you are saying that the data protection legislation flows from our right to privacy, It is about giving you certain rights in respect of your digital personal data. Now, if those rights are violated, there should be some remedy or recourse to you. But, as this bill points out, you can't go to a civil court to remedy it. Today, for instance, when you enter into, well, how does any entity get your data? There's a terms and conditions of service. You say agree to it. It's considered a lawful contract in the under law. It is enforced in a certain way. It is applied in a certain way. You can still file a civil suit. Once this bill comes into the picture, once this bill becomes law, this is the one which will govern how your data is collected, and you may not even be able to file that suit just for a pure contractual remedy, because you are essentially making your claim on the basis of this particular legislation. And keep in mind, this legislation also says that you cannot give away certain rights through the contract. So in effect, what you are making your claim on is on this particular legislation. So you have a situation where this bill, as it stands through clause 23, is taking away a remedy under law. I think you just mentioned, it was just mentioned by Aarti that there is no provision for seeking compensation, right? Compensation is the relief that you would get if you were able to show a certain violation of rights. There is no claim that you can make even in civil court on that basis. It is only penalties which the government may impose. Now you may say, penalties are there, what's the problem? Let me give you a distinction, and this is well accepted in the law, that the same action, same cause of action can have criminal and civil consequences. Just because somebody can be prosecuted for murder does not mean that you cannot file a civil suit against them for causing death. Most famous example, all of us know, all of us have studied, is the Bhopal gas tragedy. There were people prosecuted for criminal offences in the Bhopal gas tragedy, and the company and certain individuals were also sued for damages because of the massive harm that they caused as a result of the gas leak in Bhopal. Now, obviously, the civil suit was settled first. The government of India acted on behalf of people, and the criminal case dragged on for ages until a verdict was given, which most people are unhappy with. Merely having one kind of remedy cannot exclude the other kind of remedy, which is to remedy the harm caused to you. So it is questionable to me if this clause which says you can't claim any damages for the loss suffered by you going to a civil court, because this ouster of civil court clause to me is very wide, it's very broad, and actually takes away some of your rights in law. There was one other, which kind of brings us to the next aspect of what the content of the right to privacy itself is. Now, the content of the right to privacy, as the 9-judge bench in the Prasanna case mentioned, that the right to privacy is not simply against private parties; it is also available against government. Right? You claim your right to privacy as a citizen, both as an individual, both against private parties and against the government. The essential content remains the same, but the grounds for restriction are different. Obviously, only the government can claim national security and restrict your right to privacy. Only the government can say, we are providing you certain welfare benefits, and therefore we might process some of your data without giving you notice perhaps, or without expressly seeking your consent perhaps. But it's not open for private parties to say that you have no such right to privacy. But private parties also can claim a certain exemption. So for instance, if they propose to amend it, but one example as it still stands so far is the RTI Act, where I as a private person can claim another private person's personal details if it is in the larger public interest. It may be in the larger public interest for me to find out is A related to B, even though that relates to that particular relationship and to be personal data. It may be important for me to find out how much is the government spending on somebody's health and family and security, because it is public money, it is in the public interest to find out. So even private parties, there are certain kinds of exemptions to the right to privacy, but it's available to both private and public, against both private parties and the government. But under this act, I'm sure you already discussed in the first session, the kind of very large and vague exemptions the government can give itself, hugely problematic. But even the government saying, we will decide, and when I say government, I specifically mean the executive government, not parliament. This is a legal distinction which I take for granted, and I realize there's a large non-legal audience here. When I say government, I mean the executive government. I don't mean parliament, which is enacting the legislation. This is the executive government which is going to determine who is going to sit on the body which will adjudicate on whether the executive government has itself violated the rights of citizens or not. Now, there are two judgments that I won't bore you with the specifics of it. There is the Madras Bar Association case and there is the Roger Matthew case. These related to tribunals. And this has been an ongoing fight between the government and the judiciary about the constitutional validity of certain kinds of conditions of service that the government has imposed on members of tribunal, the manner of selection, the terms of appointment and so on and so forth. But this to me is so egregious that where the government says, we could be the ones violating your right to privacy, but we'll decide who will be the body which will give you the remedy for the violation of your right. So it is problematic legally and constitutionally if the government, the fact that the government itself is sort of going to determine what the body is, who is going to be part of it, what they're going to, what is going to be the composition, how it will function, what are the additional powers that they have and so on. So in the larger legal constitutional problems with this body, these are the two that I sort of broadly see, which is one, it takes away your existing rights and your right to a remedy, and two, it kind of goes against some very fundamental constitutional basic features of the constitution that it shouldn't be the government that decides what kind of remedy that you get, what kind of remedy that you have, especially for an issue which relates to a violation of your fundamental rights. That is the fundamental problem that I sort of see in the way in which the Data Protection Board has been structured. If I can just take 5 minutes, Nikhil, and then we can have the discussion. There are a lot of drafting problems with the way in which this body has also been structured. Just to draw one conceptual difference, the data protection authorities in the previous versions were envisaged as regulators. Now we can debate about who should be on it, who shouldn't be on it. But broadly they were given legislative powers. They had powers to make regulations, legal powers to make regulations and guidelines and so on. They had, of course, adjudicatory powers. There would be an adjudicating member. It kind of differed from various versions what they would do. And there would be executive powers. They would have powers to enforce the provisions of the Act. Now, regulators in India generally and around the world tend to have some mix of these three powers. Merely having one or the other doesn't make them a quasi-judicial or a legislative and executive body. As regulators, it is understood, the theory goes, that this is a specialized body which understands this field of human endeavor much better than the general parliament or the general executive or the general judiciary. We give them certain powers so that they are able to ensure this sector is regulated appropriately and they carry out their function. So SEBI, for instance, adjudicates, imposes penalties. SEBI makes its regulations. SEBI undertakes enforcement actions. Likewise, the Competition Commission of India. Competition Commission of India does it, undertakes enforcement actions, hears complaints from parties, and also comes out with its guidelines and regulations on how mergers should be treated and so on and so forth. So you have examples of regulators, and the Data Protection Authority, the previous versions, clearly tended to be regulators. This particular body, it's not quite clear. Now, the initial conclusion that a lot of people have drawn is that this is just an adjudicatory body, to which my answer would be not necessarily, because on the one hand, you have said that, okay, this body will, if you can just go back to that bit about, thank you, it will determine non-compliance and impose penalties and performs such other functions as the central government may assign to this board under this law or any other law. Now, this is a problematic open-ended clause. It doesn't tell us what kind of functions could be given. Tomorrow, are you going to give them the power to make regulations? Which is also problematic legally because rules can't further delegate rule-making power to another body. Are you going to give them executive functions? Are you going to give them enforcement powers? The reason I say this is a drafting problem is because if you pick up any legislation which creates a regulator or deals with a certain sector, you will find that there are multiple chapters which deal with three things which have to be read together. You read the composition together with the functions and the powers. Right? Composition is who will be on this body. Functions will be what this body will do. And the powers will be like what will be the legal authority to do all of these things. You need to have a good match of these three things. You need to have somebody, if you are giving a body adjudicatory functions, you need to obviously have somebody legally trained for the purpose. That are one of the criticisms leveled against the previous version of the bill. If you are making executive giving it executive powers, you need to have somebody who's technically empowered to know what is even happening. And for legislative functions, you'll also need someone who has like a broader policy perspective on where the sector should go. So, which is where, without knowing the composition, we can't say, is it a good idea to give them these functions? Who's going to be on this board? Are they going to be capable of carrying out these functions? Even the functions already present, we don't know. There are places where the board, where the act, the bill, what frequently says standards that be made by the board. There is no mention of standards again and again in the entire bill. The bill sort of mentions if there is a breach, you have to notify the board. It doesn't mention what are the powers of the board fully. Like there are certain functions that it mentions. It doesn't fully mention what kind of actions the board can take. It can say yes, you can do one or two other things, but what are the powers it has to enforce that, because that's an executive function. Right? If I make a complaint and you exercise your powers under a civil court, that is an adjudicatory function. But if you are required to be the body which enforces this act when somebody notifies you generally of a breach, that is an executive function. What will you have power to do? What will you have power not to do? All of that is not very clear. And it's one thing to sort of criticize the bill, but as we prescribed, which is I think a recurring theme across the board. But as a legislation, we cannot leave such fundamental enforcement aspects of the law to be determined at some later date. Because in a sense, it doesn't function anymore as a law. A law is only meaningful when you can tie the right protected or the duties imposed to the remedies that is offered. And to end with one final note, when you go back, just compare the Consumer Protection Act with this legislation. The Consumer Protection Act is at the end of the day, it is supposed to protect the consumer against corporations, against anybody who makes goods. It is supposed to provide an alternate mechanism. And even just compare the way the provisions related to the adjudication is drafted under that act with this act. You will see how much more detail is present in that legislation. It's supposed to be to make it as easy as possible for you to enforce your right. But they still go into detail because they know there are certain things which you cannot compromise on, because that guides the member on the board to know how am I supposed to exercise my power. Right? Because as lawyers we tend to assume, okay, if you are sitting adjudicating, this is how you do all of these things. But it may not be necessary that the person who is eventually in charge of all of this will have a clear idea exactly of what they're going to do. Because we find in a lot of lawyers who practice in tribunals sort of say this, the technical member in a tribunal knows the subject matter very well. But it is the judicial member who's the one who's like guiding to say, okay, this is how the procedure should run, this is how the case should be decided, this is how we should apply law to factors. So to my mind, very broadly to summarize the two broad points that I've made. On the one hand, there are serious legal and constitutional issues in the way the bill is drafted, especially with reference to the data protection code. And number two, there are serious implementational questions. There is a complete lack of clarity what this data protection code will be, what it will do for us, how it will even function, what it will effectively end up to. So, this to me suggests a complete lack of care in the way in which this has been drafted. That you've not really thought through what you're trying to do with this important body. It's not just a body which is there to advise the government on nice things, but it's supposed to be the remedy that we have for protecting our rights with respect to personal data. And the fact that there isn't enough detail provided here, there isn't enough thought behind a lot of this is what worries me. So I'll stop there, and maybe we can have some discussions, questions.
We have about 20 minutes, Alok. That came up in one comment that came up in certain closed door discussions in Delhi that I'm aware of was the fact that this is great. This board idea is great because anyway regulators are not very effective, and someone said that there are India is like there's a large number of failed regulators in the country, and when the executive has had to take over lawmaking, rulemaking, whatever. Someone was talking about the fact that, or the allegation that the TRI itself is directly responsible for the destruction of two industries. I don't know if it's true, but everything looks great if you look at it from the outside. And so having another regulator instead of an adjudicating body is probably a better idea. Do we need another regulator here?
Yes, because let's kind of understand the modern regulatory state as we have come to see built around us. It's not just that India is the one country trying this out of the way idea of doing this, because the whole idea that we have to have regulators for specialized functions accepts that it's not possible for generalists to be able to get and understand these highly technical and specialized fields. Generalists may have a small limited role in administration and so on, but these are highly specialized and technical fields which cannot just be managed by someone who also tomorrow might go to the animal husbandry department or the fisheries welfare. No disrespect to those departments, but it cannot be someone who just generally knows administration and management, who runs who is just to be in charge of an extremely specialized sector of the economy. And I would even say, as a lawyer who sees this, I don't think I'm fully qualified and competent to understand this sector. It needs people who have that rich experience, who have the technical knowledge, and you're not just going to randomly pull them out of nowhere. It's not going to come straight out of the state government, it's central government. It's an abiding problem in Indian government. We don't have that capacity for this. And I completely agree that it's a nonsensical argument to make all our regulators. That's just ad hominem. I think we have examples of regulators which have failed at their jobs. I will fearlessly say IRDA is the worst example of a regulator in this country. But we've had regulators which have more or less done a good job. I know individuals may feel differently, but we have a functioning banking system, which is thanks to us. The difference between a Ponzi scheme and a bank is a regulator. The difference between gambling and the stock market is a regulator. So the fact that we have a functioning stock market, actually we have a functioning, just to give you two examples. Yes, individuals may of course suffer, there may be companies that shut down, there may be individuals who are affected. But it's sector-wide. No one can say that India's stock market is a complete scam, nobody wants to invest in it, nobody's putting that. I mean, that flies in the face of it. And in a highly specialized area like this, where you can't expect that tomorrow whoever is secretary may be will have immediate in-depth knowledge of how, of data analytics, data sciences, how big tech functions, how the government collects data, and will therefore be able to do a fantastic job in understanding data protection. I think that's defined here.
They'll form committees. What's wrong with that?
Good luck. Because committees, somebody said the committee should really just expand to committee. Because a committee does not offer, you have to empower a committee, you have to have a certain level of knowledge about that sector built in. You have to have people empowered. People should know I am in this for 4 years or 5 years, not as long as the government wants me to. See, this is one of those fundamental things which makes or breaks tribunals and regulators. If you keep having a constant churn, nobody develops that level of specialized knowledge which allows them to really understand the sector and be able to take action properly. And ad hoc committees just don't help. They may last at best a year or so. But without giving them adequate powers, provisioning for them, funding them, giving them a staff, giving them an office, an infrastructure, it's not going to work.
So one of the cases in the Supreme Court right now is related to search and seizure of devices. If the Data Protection Board were to exist in this current state and form, and if such a case were to be filed, would I have the, or if someone is considering such a case at that point in time, would they be able to go to the Supreme Court?
Yes.
Or would they effectively have to go to the Data Protection Board? Does the board have jurisdiction over government potentially violating a user's privacy?
Factual answer, as things stand, based on this particular legislation, I don't think they would have jurisdiction.
You don't think who would have jurisdiction?
Sorry, the data protection. The data protection.
The board.
The board. The other thing is this legislation cannot take away the High Court and the Supreme Court's powers under the Constitution to examine executive and legislative action on this front. And when I say legislative and executive action, I mean if tomorrow the government were to exempt, hypothetically, all police, all CBI, all investigative authorities from every provision of this Act, I can challenge them in the High Court or the Supreme Court to say you can't, because there have to be certain restrictions, certain ways in which you collect data about me, even when you take my phone, right, for investigation purposes. So just to give you more context on that pending case, The government's defense has not been that who are you to ask if you can do whatever. Their defense is there is a CBI manual which is very rigorous about this, which says exactly how much data is to be collected, what is to be done, and so on and so forth. But the question which came from the court is this law? Is this how you ensure every single investigation takes place when you seize devices? Is this how all police officials, ED, NIA, do all of them also follow this? I think that is an independent conversation. That necessarily.
Using that as an example, can I go to court against my government for systems that they're setting up or the data that they're collecting after this bill passes in its current form, or do I have to go to the board?
No, you can go to, because those are constitutional remedies, but I'll add one flavor to that answer. Again and again we see this. Whenever there's a question of major technology which comes up before the courts, they struggle with this. Yes, constitutionally you have a right under Article 32 and you have a right under Article 26 to approach the Supreme Court and the High Court respectively. But this is the key problem. Those are not meant to get into heavy questions of fact. The procedure is not there. When questions of fact, when the constitution makers put these provisions in, their idea was that questions of fact will happen in a trial. You will be able to, if you are in Bangalore, go to your city civil court or your magistrate's court on the basis of Civil Procedure Code Evidence Act, lead evidence, have a certain set of facts decide. And that will go in appeal, or you can then file judicial review. In fact, interestingly, in the first decade or so after we became independent, a lot of constitutional cases started from civil courts. People challenged constitutionality of legislation in civil courts where they could establish facts, where they could say, no, this has actually happened, evidence was led, things were done. This cuts out jurisdiction of civil courts because that jurisdiction is not constitutional. It's kind of if you want to, but it's not like it's protected to say that you can never take away the civil court's jurisdiction in the context of constitution. So yes, hypothetically you'll be able to file a writ petition, but you'll get stuck because you'll realize you will make a list of allegations on affidavit. Government will respond to the list of allegations on affidavit. But they'll say, now who do we decide who's right here? Right? They have this person says this person says no, this person says this person says no. And we already have experience of this. Mr. Ajay Bhushan Pandey made that presentation in the Supreme Court for the Aadhaar case, and you see that presentation basically reproduced in the way the judgment was written. Now, he didn't put that, maybe there's some parts of it were on affidavit and so on, but he wasn't like subject to serious cross-examination. It wasn't something that you could say under the Evidence Act exactly this fact was proved, that fact was proved, and so on. So, yes, we will be able to make constitutional claims, but you will struggle to produce the evidence, you will struggle to produce the kind of material actually needed to prove your claim in court to say, yes, my rights have been violated. Because, again I'm coming back to this, that expertise, that technical know-how which is needed to be able to regulate certain sectors of the economy. You cannot just expect a journalist to grasp it. I mean, we lawyers are very overconfident about it. We always say, I grasp everything. What is that? Brief me one night and figure it out, and tomorrow morning we'll argue it. I'll forget about it the day after, but I can grasp it. But that's not how regulators or even judges are supposed to function. They won't lead.
Does the board have jurisdiction over the government?
As this stands, yes, but we read this along with the clauses which exempt the government from
therefore, but then the government exempt from pretty much everything, right? There is no limitation on what the government can do.
Yeah.
So therefore, by law, the board
might, this is what might happen, right? It's a little bit, because there are such large uncontrolled exemption clauses, we could just find that let me constitute the best, most independent, most effective board. Just don't ask them to hear in cases. You could do the other provisions of the legislation, which I think we discussed in the first session. The government could just exempt itself from just large parts of the law, leaving us with a board which has no power. That is also problematic, that can be challenged later. But on paper, if no such exemption is made, the Data Protection Board could have jurisdiction over what the government does. But if you read it with the clauses which give the government so much power to execute application of the law to itself, we will find that actually they don't have much jurisdiction.
Questions, comments?
More of a technical nature question.
It provides for?
ADR, alternate dispute resolution. That is the board recommends that.
Translate for non-lawyers, please.
Sorry. Remedies other than the court of law. And even otherwise, I'd assume that under the Arbitration Act, there is an option for parties under a contract to refer their disputes to a means alternate to the court. That is, to simplify the matter, suppose the contract between A and B involves data exchange, and there is a conflict regarding the data exchange, that can be referred to arbitration. At the same time, Section 22(3) limits civil court jurisdiction. There is a clause in the Arbitration Act wherein it says that you can approach the court for interim injunction. It appears there is a conflict. If I have referred a data dispute to mediation or arbitration, can I still approach the civil court for interim dispute, interim injunction or interim relief?
There is an earlier clause here. I just lost it. I had it here, which sort of says that you cannot waive certain rights under this act by contract. There is also the fact that this is a later legislative arbitration. This, if you have to apply strict principles of statutory interpretation, this is a later law and a specialized law. This exclusion of jurisdiction will take your Arbitration Act out of the picture, right? So, which means you cannot say, hypothetically, right, if I were to sign an agreement with a tech company for my data, tech company, if it violates any provision, it cannot say, oh, there's an arbitration clause and let's go arbitrate. You cannot approach the data protection board. You can approach the data protection board. However, once you approach, if the data protection board feels, maybe it might be a good idea to send them to arbitration, then it might send. But your provisions of the Arbitration Act, insofar as they relate to injunction, insofar as they relate to the limitation on the powers of the board and so on and so forth, that you cannot approach them for, because you will still be guided by clause 3 of section.
But just to backtrack, so this act, by virtue of being later legislated, cannot approach the DPE.
Later and
is like,
even I want to, because the legislation does not provide for it.
yeah, so if it's, let's say, that built by government members, so then would, for example, if the data protection board has like jurisdiction over the government, so will the principle of no one can be a judge in their own case, since they would have an interest in that, will that also be applicable?
Yes, so which is what the Supreme Court says in the Madras Bar Association case. Even giving the power to the government itself in this bill to determine what will be the composition of the board, the terms and conditions of the state through subordinate legislation, through making of rules, is problematic. Supreme Court has said this. I mean, they are still fighting over some of the aspects of these two judgments, but these are two very clear judgments on this point, which basically says if somebody is making a claim against you as the government, you can't now say, I will pick the people who will decide this.
So about a year ago, a year and a few months ago, we did an interview with the data protection chief of the Philippines. He said that the first case that they took up was where the Philippines Election Commission had leaked data, not once but thrice, of the voter details. Of course, in our country, anyone can take whatever, but there is restriction. And he said they decided to prosecute the Chief Election Commissioner specifically for mismanagement and for being responsible for the leaks. Of course, they only had recommendatory powers, not prosecution powers, so that recommendation basically led to nothing. But the fact is that they chose that case to try and it was a political decision on the part of the election of the DPA there to prosecute a government functionary because they wanted to send a message across that no one is above the board's jurisdiction, so to speak. What kind of behavior do you expect here?
Hard to say, because I won't even know who's going to be on the data protection. No, okay, because I've also been having this conversation with Bangalore in the context of judicial appointments. There are two elements to independence, and a lot of times we conflate both of them. One is like the structural, procedural element, right? Where we say, okay, your funding is secure, your term is secure, you can't be removed.
There is no mention of funding here.
No, I'm talking about concept.
No, but the bill, funding is
it's not mentioned. No, it's not.
There's no mention.
Right, no, you're right. I'm talking in the general context of things. where, like say, the Supreme Court, the Constitution protects the institutional independence of the Supreme Court and also structurally protects the independence of an individual judge, saying like, you will not comment on an individual judge's judgment in Parliament, they can't be impeached unless this happens. Those are like the structural remedies. But functioning independently is a personal trait. You can have all of this, but if the pool of people you're picking from are those who are used to taking orders from someone else, they will never function independently.
Correct.
So in a
Even
sense,
like someone could want to run above every step after retirement.
but I tell you what, let me end with a very interesting anecdote. A lot of people who write about the times in the 70s and 80s say that T.N. Seshan used to be one of the most obsequious kinds of IAS officers who would basically do whatever was told to him for whatever purpose. But the moment he became Chief Election Commissioner, there was only one election commissioner then he suddenly discovered his teeth and claws, so to speak, and he terrorized all political parties. And that prompted even a constitutional amendment. So, in a sense, this personal attribute is the hardest to predict. The personal attribute, you can have everything in place, but if it's very hard to predict how a person will behave once they are in office, once they hold a certain kind of position, once they hold a certain kind of authority. Now, we may be lucky and we may find an Indian equivalent of this Filipino person, but if the structural protections around them are weak, he'll be gone the next year.
Arun, you have the mic?
So I just wanted to dig a little deeper. Of course, they are staffed by specialists below them, but ultimately all administrative regulatory decisions are taken by the journalists after receiving inputs from those below them. So I'm just wondering because
we did have a specialist before this one, right? In a sense, he was a technologist.
Yeah, he was a technologist. We did have one before. But it is not structurally required that way, right? You don't have someone who did COBOL in college in the 80s who was heading regulatory agencies all the time. But the outcomes of breaches is always a kind of personal harm in the sense of, okay, my data is out in the wild, people are doing things to me, so they are civilly harassing me or criminally targeting me. So these are things that can be subject to generalist administration. So I'm just wondering why you feel like there has to be expertise at the highest level of the principal composition of the board.
Okay, so when I say highest level, I mean in the composition of the board generally. So if you have, say, 8 or 10 members, I'm not saying the chairperson has to be of that level. I'm saying the chairperson may be somebody who's good at managing an institution. But in that composition of the board, you need to have people who understand issues, who can bring that expert input when the board. There will of course be individual officials, but if you need to be able to have a conversation, walking a tightrope at any given day between collapsing the economy or not collapsing the economy. So you need to have people who know what can be like. There may be a person, like say who's a person who knows how to run an institution, right? But within the deputy governors of the board, there are 8 or 12 of them, if I'm not mistaken. You need to have people who solidly understand monetary who understand fiscal economics and where is macroeconomics and where is important. So I'm not saying only the chairperson should be taken. You need to have a mix of these. And again, if you are giving them giving them judicial functions, somebody who has solid judicial training. Because right now we just use the word members. We don't know who it will be. We don't know what combination. In a lot of criminal legislation, they very explicitly say, if you are deciding a case, it cannot be one technical member. It has to be at least one judicial and maybe one more technical member. Because, to be very honest, and I had recent personal experience of this, what we lawyers take for granted how a case gets decided, people without the legal training struggle. And what that happens means that the next level, somebody is looking at completely incomprehensible stuff. People are looking at completely incomprehensible stuff. Again and again, we find courts struggling, especially because of a shortage of members. A lot of technical members and tribunals decide cases. They're like, we can't make sense of this. Maybe this person is right, but they don't know how to write a judgment, they don't know how to adjudicate a case, they don't know how to follow this particular procedure. So they have to send it back because it makes no sense to them. So in that way, when I mean technical, I don't just need the chairperson of the problem. You need to have within the composition sufficient knowledge, people with sufficient experience, sufficient awareness of the field and what is going on, to be able to make for an effective regulator on the whole. Because I'm not just talking about any one function. If you're giving them legislative, executive, and judicial, they need to be able to do all.
Neha has the mic.
I don't know if this is a case of odd drafting or if I should read into this. The board may, after accepting the voluntary undertaking and with the agreement of the person, so vary the terms. Now, shouldn't, so how does this play out in practice? If you're a business, you come to me and the board, do I give you an in principle acceptance that I will accept your voluntary undertaking and no further penal action, no further action will arise? Because if you are having any kind of discussion on terms, shouldn't that happen before the agreement is accepted? So is this, should I be reading into this, or is this just...
No, this is just awful drafting. Okay. Because generally, right, when you give a consent decree, let me put it this way, right? When parties consent, not as if court is accepting the consent. The consent decree is what reflects those changes as well. So it should ideally read the board may, after receiving the voluntary undertaking, accepting is a wrong, accepting is closure of that process. The board may, after receiving the voluntary undertaking and with agreement to give the voluntary taking, vary the terms into, right? Because that's what gives it finality. So it's the kind of loose and shoddy drafting which is, to be very honest, across.
Will it stand?
Very honest, as I would interpret it in good faith to say maybe accepting means receiving.
Okay.
Right? I can use various interpretational techniques and tools to say accepting actually means receiving, otherwise this provision is nonsensical, it will not be capable of being implemented. But you don't want to find that out after a law has been passed. The law is supposed to provide you certainty in the first place.
My question is the opposite. Can I go to the board and say first to accept and then we'll sit down and have a discussion?
You could.
It's a serious question.
No, the reason why I'm saying that is because we don't know who will be on the board. Will they have the legal training to be able to respond to say, that doesn't sound like it works? This is, I think, how I should interpret it. It may be somebody who sees the word accepting and says, okay, then I think I have to accept it. And therefore, then I can't vary it. And then may try to vary it after you accept it. So you realize the consequences of trying to take that kind of interpretation.
Okay, but you are applying judicial standards of a consent decree to a body which is not a court, right? So,
not exactly judicial standards, but this is carrying out the judicial function. At the end of the day, this is a judicial function, it's adjudicating between rights of parties. So it will have to apply some level of interpretation of this.
Just before I come to Siddharth, on breach, the question of right to redressal and in terms of incentives for consumers to actually file a complaint when there's a breach, they can't receive compensation under this. Just curious about from a breaches perspective, how does this, what kind of remedy does a citizen get for the breach? What's the incentive for them to go and file a complaint with the board? How does this work and how should it be?
Which is exactly my incentive. Under the law, if my rights are violated, I have to have some way of seeking redress. Now, the way of seeking redress generally is through civil court.
Then effectively, folks will start to, instead of going to the board, will start going to the court.
And then the court will find 22-3 and saying, I can't take up this issue.
No, but that's a civil court.
Yeah. So that civil court's jurisdiction is excluded because of this. So, which is, it may be possible, again, I'm speculating a little bit here, the court might say, since there is nothing here which expressly excludes grant of damages, maybe you can go to a civil court to seek damages after a finding of penalty or after a finding of breach has been made and penalty is imposed by the court. But it's a little bit of a stretch. And to me, I start with the more basic principle. If privacy is a fundamental right, if my personal data is part of my right to privacy, I should have a remedy in court. It is not, forget, incentive is a second order question. My first point is I should be able to go and claim this remedy for the violation of my right. So, in a sense, you're right. The second order problem about who will then go to court. You're right. Nobody will go to because you're effectively.
My point is nobody will even go to the data protection board.
Yeah, sorry, I meant data protection. Yeah, data protection. Because you're effectively taking away whatever my right to receive them to be compensated for my loss. Even that is being taken.
There also seems to be no time frame for informing the board about breaches, etc., etc. None of that is there.
No obligation of the board to make it public from what I could make out. Nothing which says that breaches shall be immediately notified.
But I think there is something, I think one of the clauses.
There's something which is covered. At least I couldn't make out anything specific which said you have a right to know specifically if somebody has informed the board of a breach. Oh. Okay. Sorry, if you don't mind, one last question because I
okay. So that my question is essentially if we're stuck with having a data protection board as opposed to a data protection authority might be more conducive to moving things forward, and it looks like we're in the worst place than where we started. And I was wondering if either we have the board where the law won't say anything but they'll do what they like, or you have the act which tells you that they'll do what they like. So I don't know if is the previous position actually better than this, having it codified, or are we just stuck in this odorous data protection also?
Let's not make the perfect the enemy of the good, or to a place where they can eventually work as they are fully intended to. But if you set them up for failure, they'll never get there. If you don't give them powers, don't give them independence, don't give them funding, don't give them adequate capacity to enforce the law, they're going to fail no matter how many days we wait. But if we at least empower a regulator appropriately, there's a chance they'll get better as time goes on. It's not as if in 1980 he was the best regulator in the country, or rather were able to do what they can do today on that. They learn. Regulators also learn. Regulators learn from their mistakes, they make mistakes, they figure out, they understand the changing environment and respond to it. But we have to give them that capacity to respond to the changing environment. That is not what this bill does. At least the earlier versions provided enough basis for potential success. Let me put it. I wouldn't say that they're the best examples of how you should draft for a regulator, but at least they provided enough basis for potential success.
Alok, I know you have a call to go first.
The biggest exemplar of that is perhaps the provisions on cross-border data flows, which rather sadly are just a single paragraph of about 4 lines. As per the law, essentially what we see is that the government will notify certain countries as acceptable to transfer personal data to, and the conditions of that notification, we really have no idea about what they're going to be, because as usual, they will be prescribed at a later date. All we do know is that personal data is defined in the bill rather specifically as any data about an individual who is identifiable by or in relation to such data. So that's sort of the larger remit of the provision itself. And Sarvesh will go into this in detail later as well, but the transfers under this provision are also exempted under certain specified circumstances. So that could be when enforcing a legal right or claim, when trying to investigate a crime, for example. And the central government can also notify further exemptions as well, especially in the case of state instrumentalities, which is sort of defined in the interest of sovereignty and integrity of India, and also when for research, archiving, or statistical purposes as well. So small provision with a lot of scope for exemptions as well. What's different about the provision, like I said, perhaps everything. I mean, when earlier versions of the law subcategorized personal data into sensitive data and critical data, and that is because they sort of posed higher privacy risks to data principals, which is why they deserved more special treatment. Those subcategories aren't mentioned in this, as we've already discussed. So, along with that, the restrictions are gone as well. There's also the question of data localization. Does it exist or does it not? And yes, we have a whitelisting approach, but does that imply that every other country that's not whitelisted, data transfers to those are blacklisted? Does that mean that we're actually having data localization within this provision without actually explicitly saying it? So that's Schrodinger's data localization. And then we also see that the penalty regimes for data breaches when it comes to cross-border data flows have changed drastically. No provisions or specifications. We can just assume that according to the penalty schedule, we would perhaps be up to rupees 50 crore. So that's sort of the general thing of what's changed. A lot essentially, and now I'd like to hand it over to Udbhav and Nehaa to kind of tell us how they view these provisions and how they impact businesses and general data flows.
mics are on. Here, take this one.
Test. Thanks. I mean, how does it impact browsers? I don't think anyone can answer how it impacts anybody, like with how deeply the provision is generally drafted. But I do think there are like maybe 3 high-level points that I'd like to make on both my personal read of the cross-border data flows.
Can I
Sure.
specify the question better?
Sure.
I mean, my reading is that everything's blacklisted because you have to have a whitelist.
Sure.
In the presence of a whitelist and without the infinite period of the whitelist isn't notified, what happens to process?
Okay. So, I mean, at least in my read, it's not necessarily an implicit allow list block list approach, and that's primarily because the law gives the government the choice.
What's the point of a whitelist if everything is whitelisted from the get-go?
Yeah. So I think that like the reason the provision is drafted in the way that it has is what we would most likely see after this is something like the cross-border flow of data rules 2024 that would come out under the law, under which the government would use an executive framework to broadly come out with the criteria under which cross-border data flow would take place in India. And I think that at the highest level, the way that cross-border data flows at least currently work in most jurisdictions in the world is there is adequacy. After adequacy, there are other alternatives. If you don't have adequacy with the country on the basis of which you can do data flows, and then there are exemptions to both adequacy and to the other things that you can do. And the other things include binding corporate rules, standard contractual clauses, certification agreements, and things like that. And now some parts of these are present in some like data protection laws, some of these are not present in some data protection laws, but I think that both in order to sort of deflate the conversation a little bit because of how vocal it had become on the concept of data localization, I think that it's the rules that will actually lay out this framework. Now, will these rules contain references to data localization? I think that it's very hard to say if they won't, but like if I were the Indian government, I probably would include it because they push the conversation a fair bit on categories of data, kinds of like localization that the data could be imposed on. And even if that is not present, I think that there are enough levers that the government would have under the current provisions to be able to get what it wants with the allow list, block list approach that you were talking about. And that's primarily because I don't think the ultimate goal of this provision is to say, here are a list of 6 countries and these are the only countries to which you will send data, because in some ways that would be worse than the data localization provisions that were present in the original version of the law, because there was no clarity around when certain kinds of data could leave the country, and even when it didn't meet the country criteria, what were the other ways in which it could leave the country, because the 2019 and 18 drafts, for example, did make references to other mechanisms, which was a reference to standard contractual clauses. So it's clear that just like many other things in the law, I think that this is a provision that's been drafted as vaguely as possible to give the government as much leeway and discretion as possible to decide what the framework is going to be, but I'm reasonably certain that whatever framework we're going to see is not going to be one page that's going to say, here are the 6 countries where the data can go and it can't go anywhere else. Mostly because I think that that would be crippling to India's role in the global technology ecosystem, and it also would be quite impractical to reasonably enforce.
So let's say this bill passes in the budget session, and then the rules get for cross-border data flows come into place, let's say in December next year, right? So what happens in that interim? What is applicable in
Yeah, nothing, right? Because I think that what the law says is the central government may, after an assessment of such factors. I think that as long as that may exists there, it means that until the central government does something, everything that is happening right now can keep happening. And primarily because of the existence of that may, and that's the reason I think it's been drafted the way that it has. Of course, this is legal interpretation. There are far better lawyers than me in the room that I think can give a turn better explanations about how this may play out. But until that happens, I don't think there is any, can the government say you can't do this data flow because we passed a law and we're coming up with rules? Yes. But does it automatically mean that the day the law comes into force, all data flows are illegal until explicitly allowed by the government?
Okay. So you had 3 points to make. I sort of
Yeah. No.
This will hold you into a question.
No, and the three points that I want to make, I think in a way I've sort of covered in the overview that I was giving. The first generally being that the mechanisms under which cross-border data flows take place, even in regulations, in jurisdictions that are far better established, are ones that take a lot of trial and error to reasonably implement. I think that what we've seen, say, with the European Union and the United States, with Schrems 2 and everything that's happened with the new executive agreement that they've come in force with, are all really demonstrate that at the end of the day, cross-border data flows are about geopolitical power, and they're about the value that a certain country adds to the global technology ecosystem and how well it can exert that value in demanding what it wants. And in India's case, I think that does that value exist? I think quite clearly. It's the reason I think that data localization was opposed as strongly as it was by players, because they knew this was not a country where they could choose to simply not comply. But I think does India, at least from what we've seen so far with these drafts, have the necessary sophistication with which it has to engage in those conversations with jurisdictions like Europe, with jurisdictions like the United States? I think that leaves a lot to be desired. Both because of the positions that it has taken in other multilateral fora, like whether it's data flows with trust that's happening at G20, whether it's the conversations that are happening at the WTO with e-commerce, all of them showcase India taking a position where the rules that would be formed under this section, I think, will look very different in comparison to what India needs in order to maintain its place in the global stature. So that general point of there's this quote, right, which is that man's reach exceeds his grasp. So I think in this case we need to make sure that the positions that we are taking and the outcomes that we're pushing for are outcomes, firstly, that we can actually achieve, and secondly, that end up serving our interests as best as possible. And that does not mean just let everything go wherever, but neither does it mean, coming up with an explicit allowed blocklist approach. The second point was, I do think that there is more than enough scholarship, thanks to the earlier version of the law, that does place and already create the framework under which India's cross-border data flow regime could operate if it were to be done in a sophisticated manner. Large parts of it existed in the previous drafts of the bill. I wouldn't be surprised at all if we see very similar language in subsidiary rules that are created under this. But it's also really a little bit of an opportunity, right? Rather than necessarily getting into the political debate of passing the cross-border data flow provision that has to, pass political muster and make it through parliament and survive that entire hype cycle, I think there is a little bit of an opportunity, definitely very much like a diamond in the dirt type opportunity to maybe craft a set of cross-border data flow rules that gives India what it wants, but also leads to the central government cooperating with the different stakeholders to form a set of rules that end up balancing interests in a better way than I think the previous drafts had, and I really wanted to highlight that opportunity. And the final piece is that this is arguably one of the provisions that is being looked at the most carefully by jurisdictions elsewhere in the world. The things that Alok was talking about around around the data protection authority independence, that overall framework is definitely the sort of more compliance-heavy part that I think governments and companies are caring about a fair bit, but the reason they care a lot about this is, depending on the position that India takes on this, it's actually going to implement, I think in the next 5 years, it's going to shape what happens for cross-border data flows everywhere in the world. Whether it's countries like South Africa and Brazil, whether it's many other countries that have similar ideas, where I think the closest market that we have that's attempted to do something like this and has honestly reasonably successfully done it is China as a part of their personal data protection. All those provisions are in a very interesting mix of security assessments, the provisions of advocacy, agreeing with cross-border data flows, and I think whatever we have to come up with needs to make sure that if India is trying to carve that fourth path away from the US, China, and the United States, and that this provision adequately reflects that as well, because it's something that we can very much galvanize large parts of the world around. So yeah, those are
Neha? And Udbhav, honestly, I'm still not convinced about I see it as a blacklist.
Yeah, I was actually just going to start off with that. I think I agree with you, Nikhil, and I think you're straight off going to have a disagreement with the panel, and I think that we were just talking about how we really like that Schrödinger's cat phrasing on data localization. The way that we're reading the law, I think we're I for one could not understand why people were celebrating the removal of data localization, because this to me pretty much reads like de facto data localization. What is the point of having a whitelist of countries if the converse is not true? And we also understand the Office of the Minister of State has been having a bunch of these consultations in Delhi on the text of the bill, some of which members of my team have been a part of. And I think they're quite clear that they are going forward with this whitelisting approach. What the final form it takes is something that we all have to see. I'm pretty sure that we'll see, like Udbhav was talking about, some version of cross-border data flows, rules, etc., coming in. But I think that, and also goes to a lot what Udbhav was actually talking about, right? Like it's tied in very closely with the government's strategic interests and trade objectives. It's a huge bargaining chip when you're negotiating international treaty negotiations that you don't want to let go of. It's been a recurring theme that's come up, including in the UK Free Trade Agreement, for example, right? What kind of market are you going to allow for cross-border data flows in your country? So part of it is that. Part of it, of course, is this thorny issue that we've been talking about for 5 years about law enforcement access to data, and the government being very concerned about how exactly it's going to get access to data, in addition to the level of protection that Indian citizens or residents' data will be subject to in a foreign country. And I think that they will take all of this into account when they are coming up with this sort of white list to which data can be transferred. And I think the view of the meeting is also, I mean, unless we give you a white list, you do sort of de facto localize, right? Because if you're not allowed to take it out of the country, or if you can only take it out of the country to a list of pre-approved countries, the converse of that has to be true, which means that you pretty much have to store data in India. But your earlier question in terms of how will this play out, I think that they might account for all of this when they're notifying different provisions of the law into force. I don't think, for example, that they'll say Section 17 is enforced today without having perhaps given some thought to what is this list of countries. In fact, I think he had said at some point that to assuage concerns about this de facto localization, they want to introduce a list of countries in Parliament at the time that they deal with the bill. So it's possible that we might see some kind of operational or execution solutions to some of these problems. But other than that, I would say, until and unless the section is notified into law, I would say sort of status quo prevails, in which case you already have some kind of data localization requirements that different sectoral regulators are already imposing on certain kinds of data. And that might well continue to be the case after
Just a query specifically on that point of introducing a list. A large part of the adequacy conversations are negotiations. If you introduce a list, but at the time that you're introducing a bill, you basically take away a part of negotiation because you don't have time to negotiate the list.
So you might introduce an indicative list, because very often what's happening now is we're getting these questions already from our clients, right? What should we do? Should we get ready to bring our data back to India? What happens if I have a branch office in India but I'm headquartered overseas or vice versa? Will I be able to move data around? What should we tell our portfolio companies about markets that they're thinking about expanding into? Will Singapore be on the list? Will Australia be on the list? Will South Korea be on the list? And quite frankly, I don't know, because the government is also very clear that it's going to decide what these factors are and whenever it's going to make this determination. So that list might be indicative, right? That list might be, these are the 20 countries with which we will attempt to broker an agreement for the flow of data across borders.
So we've gone from the clarity of the previous version, which leaves too much for
You don't like either.
Don't like either. Any other initial thoughts?
No, I think this is it. I think it's deeply shrouded in uncertainty, and I'm personally quite clear that this is the fact of data localization, so I'm not a fan of this clause.
So my favorite question around this particular subject is the strengths question. As we look at in the next session, government access to data is fairly unrestricted. Are there grounds for strengths to go to court to India and is being processed over here where there are no restrictions in terms of government access to data? I know the data protection bill doesn't apply to the data of foreign citizens, but what applies then and what protections are being accorded to the data that's being processed over here? So should this data transfer therefore be disallowed? Is there room for that kind of a case to be filed in the EU?
I mean, so I've both met and seen Shen speak a bunch, and I think that this India is not on that list. And the primary reason that India is not on that list, and it may not be Shen, it may be someone else. So it's primarily because the data of European citizens comes to India already. The way that it works under the GDPR is India is not on the adequacy country list. There are only 12 countries in the adequacy country list.
Because standard contractual clauses.
Standard contractual clauses, binding corporate rules. There are some, like the finance sector has a code of conduct with the EDPS. There are a bunch of these.
I'm going to give you a hypothetical, right? There is banking data of someone who's become a citizen of the EU, allegedly defrauded citizens of India and fled and bought citizenship in the EU country, therefore EU citizen. Money is kept in a bank somewhere in the EU. That data is being processed by a BPO over here. Your agencies would go to that particular BPO and say, I want to see that data. What stops this?
Yeah, so nothing. The thing is that they could do it today. They may have done 2 years ago.
But the law basically creates those grounds and brings clarity to the fact that those grounds exist, and then those grounds themselves can be used to mount a challenge or something.
Yeah. The thing is that I think that the law, you're right in that the law does create, I would say almost more grounds. It's one more thing that you'll add in the memo that you as a cop will ask whoever your lawyer is to prepare, but you can go do that today under the CRPC, and in fact it may have already happened, and since we
So therefore there is really literally no protection.
Yeah, but
to data of foreign citizens being processed in India today and in the future.
Yeah. The thing is that also the way that firstly, no, I think that there are some there are some protections to the extent it depends on how you are structured as a company, what legal resources you have, how much you create entity distinction between who's processing it, what your role as a BPO processor is. And from what I understand that there is a fairly strong understanding between the BPO industry and the Indian government on this point, otherwise the mechanisms under which a lot of this currently taking place would collapse. But realistically speaking, the hypothetical that you're laying out is a hypothetical that can play out in Europe today. It can play out in the United States of America today. It can play out in Australia today. And there is no government in the world that has a law that says the data of any foreign citizen that is present in my country will follow a different legal process than the data that of my own citizens, my own agencies have to follow. That's simply too much of a breach of sovereignty for any government to necessarily agree to that. The best case scenarios that exist are the kind that the current executive agreement between the US and the EU have, where they're setting up a separate court, there's a separate review procedure, EU government, EU citizens will be able to challenge US law enforcement agencies in a US special sort of review court that's been set up to demand access to this data, but it's taken 2 legal cases and 15 years for them to arrive at that point. And also then I think it's going to be very interesting to see how it actually plays out in practice, right? Which person is going to get on road right from France, come here and say the NSA is getting my map history, I want to sue them in a US court. So I think that there is value in that hypothetical, but I do think that one must really probe can that hypothetical play out anywhere else in the world? What restrictions do other countries impose to prevent that hypothetical from playing out? And what additional restrictions is India imposing? So if this is a part of the broader government access to data surveillance reform question, absolutely. It'd be much better if someone has to go to a judge before they get access to that data as a hypothetical. But neither is it the open and shut case saying just because this happens, or obviously this means that the EU will never do adequacy with us. And this is a question that, because as a part of the adequacy process, the EU Parliament has to approve an adequacy decision, which they've done for Australia, which they've done for South Korea. This is a question that everybody raises answers for, and if you look in these records of public, if you look at the responses they get, they literally it's a lawyer summary of this is the law in this country, this is what it applies, this is the process that they follow. Thank you. Nobody ever really actually answers the question will the South Korean police be able to access a German citizen's data in South Korea, and how will our adequacy decision prevent or protect that? So that deliberate ambiguity and some discomfort, I think, is very much going to be a part of the conversation, regardless of the law we are in. But Neha?
I don't know how to talk that really, but
maybe I'll just nothing at straws for government accountability.
Yeah, I don't disagree with what Udbhav said, right? Because I also think that the way that it played out with the US was different, because we have FISA, so on and so forth. We don't have laws now that specifically single out for instance. All of us are in the same boat, right? Whether it's good or bad. And likewise, then that's also the remedy conversation that you extend there. I have the right to, currently, what is my remedy as an Indian citizen? I go to the court, to a writ court, file a writ and say, hey, my fundamental right to privacy is being violated, assuming that I know in the first place that this breach of, I even find out in some way, shape or form, right? Now it's very difficult to even find out in what circumstances the government is getting access to my data. And I think that in fact there have been a couple of those cases. I don't quite know what the status of them is, but wherever people have been able to find out, I think they have filed a writ, gone to a record and said, hey, privacy, I'm going to write to privacy. So I think that's the same standard that you can apply to foreign citizens as well, because it's not a citizen's.
Any questions, any thoughts? Okay, two here. First,
I had a question about consent again. So in the context of giving the data for cross-border data flow, is there an idea that the data principal will be involved in getting consent for doing this? I'm not sure if that is under discussion at all. How does it play out? And I'm not sure if the previous versions of the bill talked about it. So if there is a consent, like for example, about the child privacy, she was talking about the refresh of the consent once the person reaches 18 years. And this is a special case of processing. This is given the geopolitical context in which this is played out, this is such an important data, special case of processing. Will the data principal have a choice for consent at this? Because it's the agency seems to be only the central government.
So, two questions if you will and should.
Really, right? And I missed the data consent discussion, but I imagine this might have come in there as well.
That being consent itself was about an hour and a half.
I gather. But I think the previous version of the bill did have this language that said you needed to take consent of the data principal before taking money to overseas. I don't think that language exists here anymore. And I also imagine that for cross-border data flows in particular, you would look at one of the deemed consent clauses and try and see where it was possible for you to make out a case of, a reasonable expectation that your data might move overseas as well. But there's no mandate in the law that says, right? Because the language is also where you're relying on consent to be the basis for processing, then you must give a notice, so on and so forth. So, yeah, no compulsory need to take your consent to take data basis.
The only thing I would add to that, and it's not an example from what happened like in India, because Neha's absolutely right, the law doesn't touch on it at all, is what happens, so in GDPR, the first derogation to adequacy and to all other forms of cross-border data flow is explicit consent for cross-border data transfers. It's explicit, so it's a higher threshold than just normal consent. If you check your terms and conditions on your Google account, your Facebook account, it's now standard procedure for terms and conditions to include a provision that talks about why your data may be sent around to other places around the world as a part of processing. It's very difficult to imagine that meets the threshold for explicit consent, but governments have recognized the fact that if I explicitly consent for my data to go somewhere else, then that should be one of the reasons for which the data should be able to go there, regardless of the kind of adequate protection being available in that market or not. And I think in this case, if one imagines how the rules will actually end up playing out, and first part of the rules deals with the list of countries or the criteria by which the list of countries will be decided. Second part says what are the other reasons that you can send information outside. Third says here are the derogations in which you can send the data outside. Then at that point, would I advocate for consent being one of the mechanisms in which people should be allowed to send certain kinds of data outside? Probably yes. because if the whole goal of data protection is to protect the user's privacy and you don't empower the user to agree to certain kinds of processing, then I think that it sort of goes away from the idea of what that terms and conditions contract really is. But whether the Indian government will do that or not, I'm not so sure. Primarily because it does away with the whole concept of having this rule if you can just consent to it. Because if you just consent to it, they just include it in their terms and conditions, and then it'll be like this thing didn't exist. Because everyone will just include it.
So just before we go to Alok, another sense question, saying that I don't want my data to be processed in the US because of privacy surveillance, etc.
I mean, I think that process so many levels at which I think you should be able to make an argument for that in court. Lawyers will definitely do better. But I think that the challenge in India would be to prove that the level of protection that my data has in India is better than the protection has in
Because there is no protection there, right? So I get that.
Yeah.
But I'm not talking about differential protection, right? You're basically saying I don't want foreign surveillance on my data.
Correct.
I can go and file a separate challenge on local surveillance and ask for surveillance reform and already cases there. That's separate. But I can also say foreign surveillance as a separate thing and say this bill doesn't protect me from foreign surveillance.
Sure. I mean, I guess depending on the judge you get and the bench you get and how it goes, whatever stuff can play out. But I think that in realistically speaking, the odds of you being able to claim that the Indian government has a duty to protect you from foreign surveillance for data that you have consented to send to another jurisdiction is an interesting question. I'm not sure to the extent to which they'll be able to say you cannot do it. As in the foreign surveillance is not okay at all, because right now you are consenting to it. When you agree to the terms and conditions, you know that it is going in those places, and there is a line there that says that the laws of the country where the data is going to go will apply to this data. If a court decides to interpret it another way, that's fine. But that's also I think we're now in very rarefied blue sky territory. Yes, no, but I don't really have to think about it.
I just had a follow-up question about the breach which may happen once this cross-border data.
Let me respond to that.
Where is the right duty violation, right? Because this is a private contract that you're entering into. You right now, the only recourse that you have through your fundamental right to privacy is against the Indian state. When you say state action, the state acted in a particular way which led to a breach of my fundamental right to privacy, and therefore this is the remedy that I am entitled to. That's the way that put this on me, everything that flows from it is currently structured, right? How do you make that argument, right? If you say foreign surveillance, you're basically saying that because the state failed to safeguard my data against foreign surveillance, there has been a breach of fundamental right to privacy by the state. I think that's
and the state should be directed to create laws to protect my data against foreign surveillance.
Sure, which is what they want to do with Section 17, right? They're saying we will tell you a list of safe countries based on 50 different factors. Also because fundamental right to privacy is not just exceptions,
and
including...
if they find adequacy, let's say with the EU, whether there is a limit with the US where there is NSA surveillance, then I can challenge that. As in that adequacy.
No, because your right is not the only thing. Even under the fundamental right to privacy, it's not an absolute right? The state does have the power to make exemptions for a whole bunch of different reasons, including national security, so on and so forth. I don't think it would be far-fetched, and I mean there's a list of 10 to 12 grounds in that judgment that you can say this is a legitimate state purpose on the basis of which in the development of India's economy, the government will say we do want to have this cross-border data flows agreement with the United States. If you have a problem, please don't use services that send your data overseas.
And the only thing to just add to that is of all the 12 countries that are on the EU advocacy list, all of their intelligence agencies can gain access to data that is there in their country. The difference is that the adequacy decision does not mean that no foreign intelligence agency could never get access to your data. It means that the NSA can't open a tap and put a bucket inside and just collect everything that's falling and then do the kind of surveillance that they do. The reason the Schrems judgments have ruled what they have is the potential for mass surveillance. This idea that as long as an intelligence agency is making a necessary, proportionate request for information that has a proper national security interest, then those are things that the agency would always be able to do. I think in this case, if we were to be able to prove that, say, the intelligence bureau does have the potential to carry out mass surveillance for foreign financial data that enters, like any BPO company. Yeah, then actually there will be, even before the legal case, there will be a geopolitical fallout that I think India will have to reckon with, because that's going to be disastrous for the industry. And there's a deeper question of whether we have the capability to do something like that, because that requires very sophisticated technical infrastructure. But for intelligence agencies, being able to access your data is not the problem. Then being able to do it in an indiscriminate manner, sometimes in a manner that your own local domestic agencies cannot, which is the primary thing that happened in Shen, that the EU law prevents them from doing what the NSA is doing on their data, and then sometimes even sharing insights with their counterparts in the European Union. So that, I think, would be a much more interesting challenge if you would tell me.
Let's see what happens there. Sorry, Arun's been waiting for a while. Did you have a related question or a separate question?
I just wanted to know if there's a
whole host of reasons. And so that kind of brings me to the Cloud Act, which has been around for so many years now. And last I asked the Indian embassy in DC if they were negotiating an executive agreement with the US. They replied by sending me a copy of the Cloud Act. So at that point, they were not very well equipped to have these discussions. So my question to you now is, what should India do to actually get to a point where we can negotiate and conclude an agreement with the US under the Cloud Act, and what happens next?
Just law, they suggest parallel mechanisms that you set up only for requests from US data, but I think that none of them are questions that really pertain to cross-border data flows directly, because those are questions for how can Indian police ask for data that's present in the United States in a faster manner. And that is a distinct question from cross-border data flows, because it doesn't deal with any of the things about what the US can do with our data once it is present there. That just means that the Indian government or Indian agencies don't have to follow MLAT procedures. So that distinction is a very important one. One is about us getting access, and this entire section is about them getting access to our data and what they do.
Okay, I'm going to come here because he's leaving without asking the question.
Sorry for that, thank you. No, I just wanted to know if there is a breach in terms after the cross-border data flow has happened. Protection board that we talked about in the previous session, would that be enough to have the jurisdiction to resolve those things as well?
See, the subject to one of the entities, at least like the transferor entity perhaps being India, right? The jurisdiction of the board, of the applicability of the law itself depends on a couple of different factors. Yeah? Processing is pretty much any activity to do with data, right from collection to cross-border data flows to whatever, so on and so forth. It could be 50 different things. Or the presence of the organizations in the country, right? There has to be some kind of something that's tying me back to India for this law to apply. So in the situation that you're talking about, assuming that it's an Indian data fiduciary, Indian data controller that's sending data overseas, I still very much have the obligation to tell the Data Protection Board of India, hey, there is this breach that has taken place. I move data from, you'll have to report all of the facts. I move data from country A to country B, in country B, this is a breach that took place. That data protection authority may also exercise jurisdiction depending on what the law of that particular country states. But since you're a company that's based here, on your watch, technically there has been a breach that has occurred. You very much have to tell the board. And then,
very quick.
I mean, if there was a global data protection act that applied to all countries around the world, yes, but otherwise not necessarily, because consent, then that is premised on the idea that the individual is comfortable with the level of protections that are available in the country to which you are consenting that it should go.
But if you look at GDPR, data controller has an obligation to ensure that the data that is processed in a third country or by a third party has adequate technical organization which is to protect that, right?
Yeah,
so that's an obligation of the data controller anyway.
So the thing is that for at least the way that it's framed as a derogation in the section that deals with cross-border flows in the data under the GDPR. I agree with you that I think if you were to compare what is greater, the freedom that the data controller gets as a derogation to cross-border data flows for consent, or the obligation to make sure that wherever the information goes, it is protected at an adequate level. I would personally also just morally agree with your interpretation, which is that you should only send it to places where the consent is adequate. But at least the explicit provision in the law and the way that SCCs and DCRs and all of these things are designed, they all have that adequate level of protection, but it's also very clearly not enforced that way because data comes here. And India does not have the adequate level of protection. Yeah, exactly. No, but even if it's contractual protection, the contractual protection is premised on the fact that the controller has the ability to, in contract law, exercise the adequate level of protection if something goes wrong. Right? So imagine I sign a contract saying I will protect your data like I protect it in the EU, and then but when the enforcement directorate knocks down my door and takes my laptop away, you are complying with Indian law at that point in time. Saying that I'm complying with a contractual obligation in Europe and therefore I'm not going to share this data with you is not an option that you have under Indian law. So that tension, which is inherent in all cross-border data flows, I think will continue to apply in that case as well.
Hi, my question and not my question is not on the screen, but it's in the operative section, right? My question is as follows: do you see this as a potential scope for defining more sensitive categories of data in terms of what can be transferred, and more importantly, where, depending on geopolitical scenarios? For example, the US, India being an outsourcing jurisdiction, we may have, especially employees headquartered in the US, so you may have, for example, of the Indian subsidiary, you may have Indian employee data, social security numbers to an extent, Aadhaar details, or maybe not Aadhaar, but at least other identifiers, be able to be shared overseas. But for example, not so with a neighboring country, right, where there may be limited items of data. For example, trade of goods, right? So do you see an evolving approach in terms of the data that's really specific?
Yeah, absolutely. And I think the intention in deciding both the kind of, in deciding the categories, the kinds, the sensitivities of data, as well as the geographies to which it would go. And I think you also read this together with the fact that the law now has taken away specific categories, right? It's all just personal data. There is no critical data. There is no sensitive data. But it defies logic that the government would not be thinking about a certain subset of critical data, which it definitely would not want to go to.
What about sensitive data?
And or even sensitive data,
right? Do you think
right?
there should be a classification?
I think so. I also think that we're de facto, in any case, going to see a classification, right? This will happen in one of two ways. One is either you will have an approach where sector-specific regulators might, and they'll definitely want to have a say where they regulate different kinds of data differently. Although the government's view on this is that, we'll harmonize everything, don't worry before we release a law, which I already know that different sectoral regulators do want. Like the NHA wants more things in the law than there currently is. But yeah, I think that intentionally kept it vague. And I would not want, as the Indian government, all the data that can go to the United States going to a China or Pakistan. Right? So it just defies logic that it would, that they'd be okay with it.
We're going to switch to the government access to data section. We just ask and then
that a complete blacklist is even possible unless you're going to prevent your citizens from traveling to these countries. There are these sorts of issues that are practically going to come up, right? If you have an Indian traveling to China, and even if you want to put China on that list, there are some aspects of his data that will have to necessarily move overseas and back, right? A complete blacklist, I don't think, or a complete blacklist without having subcategories of data. So
that's a really interesting question. If I take my device to a different country, what happens there?
Or if you're applying for a
blacklisted country, what happens?
If you're trying to book a hotel or you're trying to book whatever it is, how do you stop your personal data from going? How do you stop it?
Practical answer to that, like incidental use, personal use, so on and so forth. Like it would be a ridiculous scenario where you would have the law imposing restrictions on, whether or not I can take my personal device to a particular country. So I don't think those cases are going to be stuff that it worries itself with, but do you feel?
No, I don't feel otherwise, but I can also, like, for example, imagine a European citizen protected on GDPR comes to India, signs into immigration, gives his passport, gives his address, gives his phone number, like bunch of personal information. And then, like, you know, the police goes to the immigration authority of India and says, we're investigating this person for a crime, give me the data. Nobody is going to say GDPR, like, you know, as the defense at that point in time, because that's not what the law is designed for.
Hi, my name is Akshat, and very quickly I'm going to take you through government access to data and the kind of exemptions that this bill provides. First of all, we can classify the kind of powers and the kind of access and exemption into three categories. First is the kind of exemptions that the government can grant to instrumentalities of state. Two important things to note here. The definition of instrumentality of state is not clear. It doesn't mean who all can get access to data. And the second thing is that this kind of exemption can be granted to all the clauses of the Act, and it's not limited to certain provisions. Government can also retain personal data for an unlimited amount of time if you look at clause 18.4. The second kind of exemption is the central government can exempt data fiduciary or a class of data fiduciaries from certain provisions of this Act. These include things like issuing consent, and it includes right to information, appointing a data protection officer. So certain class of fiduciaries can be exempted from these provisions. This could be private entities, companies, websites collecting data. So what can be exempted, on what basis? This kind of private companies will be granted exemptions that is not specified in the law. It just says these things can be prescribed data. So the third kind of categorization, a very broad categorization, includes a lot of things. Exemptions can be granted for legal rights or claims, for judicial and quasi-judicial functions, for any offense or contravention of any law. These are the broad categories under which government can grant further exemptions. It's important to note that these exemptions are not for all the provisions of the Act, but for a set of provisions of the bill. And over the years, if you look at what has been going on, the kind of powers that the government has increased a lot. In 2018, if government wanted to process data without consent, it had to be for certain specific cases, like for certain welfare functions. In 2019, these things were watered down, and the phrase that was there in 2019 was for procedural safeguards and for oversight mechanism had to be followed while processing data without consent. And in 2021, the phrase that was there was just, fair, reasonable and proportionate when the government wanted to process data, often without consent. In 2022, all of these things have been removed, and the government can grant any of its instrumentalities the power to process data and exempt any instrumentality of the state from following any provisions mentioned in the bill. So this was the basic summary. So now we'll move on to the discussion and comments.
The slide that said 2018, 2019, 2021, 2021. Yeah, what is there to comment? It's just gotten like worse and worse. But I think there are like, at its highest level, maybe two things. One, just this general idea that.
Let me simplify it for you. If, let's say, we had to do a filing and we had to choose any one of those to be brought back, which one would we choose in terms of protections?
I can't hear you.
Okay, if you had to go to any of these, what do you think offers the best protection? So in our filings, what should we put?
2018.
2018. Is there a way of improving 2018?
Yes, I mean it depends on whether you can expand what the law describing a procedure should include, whether like
or can you say that
the term
prescribe, like can you, there's no as may be prescribed here, right? So should you ask for this and have as many as
I mean I would be necessary proportionate, I would add due process after after them.
Sorry, my country.
Yeah, no, I would take necessary, proportionate, and add due process at the end of it, because like the necessary, proportionate, and due process have meanings in law that when they've interpreted with regard to how the police can intervene in the life of like private individuals, that I think importing them to India's surveillance regime is good. And then there is a law describing the procedure, like laying down minimum criteria for what the law should or should not contain are the two things that I add. The second thing that I'd add is that it has nothing about like judicial oversight / judicial review. If that could be added, then I think it would be like
If I had to go to the Supreme Court on the basis of the current law, or as it stands, would I have grounds under Puttaswamy to challenge the efficacy of this law in terms of protecting my rights under the reasonable, like necessary, proportionate detailing of the law or whatever? Like, do I have grounds to challenge this law?
I think that your odds are as successful as the current surveillance challenge that's ongoing in the Supreme Court, because the grounds on which they challenge, like the law doesn't change.
So the current law does nothing to address the current surveillance challenge. Okay.
No, I mean no, but also I mean the court would lead in. It's also not just this law, right? The court would also, the Puttaswamy standard doesn't need to be codified into legislation to apply, basically. I think 2018, you would anyway apply just necessary and proportionate to government access to data under this bill, just as much as you would do the 2018.
My favorite question on this particular aspect is the idea of privatization of surveillance from a slightly different perspective. The fact is that companies are collecting all sorts of data about us. There is a plan under NatGrid to build dashboards with real-time data access, initially from 21 databases, then with 915 odd databases, then with 1600 databases, both public and private. Is there any protection that I have from the government building dashboards on 1600 odd public and private databases and taking real-time information through APIs and whatever under this bill? So effectively, the fact that I'm giving my data to companies, am I then giving more data for me to be surveilled using to them? Yes.
I mean, yes, and I don't think that there's anything that the bill will prevent from that from happening, because firstly, just on this instrumentality of state thing, there's a bunch of case law that defines what an instrumentality of a state is. It's like if you have control above a particular thing, whether you perform a public function, yada yada yada. So it's actually public research universities is one of the nicer examples of what an instrumentality of state can be. It can be like private entity that gets most of its contracts only from the government and performs just builds roads. There is an argument actually to be made that even that may, in court, once you argue it, may be an instrumentality of the state. So it's a very, very...
Effectively, all PSUs are instrumentality.
Oh yeah, they are. I mean, if you have more than 51% of any company, you are instrumentality of the state. So that's on the instrumentality piece. But then on the piece right after that, which is what you asked, I don't the government will just say that the law doesn't apply to you, which I think is a little worse than the government saying there is no law that prevents us from doing this. Right? When it comes to surveillance, right now, say if you were to file an RTI and ask for XYZ information, they give you the national security exemption.
Next question is about what does this law do to empower me against internal sharing of data within the government? So historically, if you remember, maybe 6 years ago, 5 years ago, the UIDI went to the court and said in court that for police investigation purposes, we cannot give data. There are silos that exist in government where one agency cannot take data from another agency. Those protections are built in, but more in process rather than law or procedure, I think in most cases, right? Does this protect from data sharing and profiling within the government?
I mean, that really depends on what is the kind of exemption that they come up with, right? Because the government may at any given point of time decide to exempt any
Is
instrumentalities.
it like what you were discussing with cross-border data flows, that the Udbhav's interpretation that everything is whitelisted until the whitelist is prepared? Is there a whitelist for everyone in terms of data sharing?
No,
is there an
no,
exemption for
the
everyone right
central
now?
government may by notification exempt application of the act, etc., 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 so on and so forth, right? So you need, there needs to be a positive action from the state saying these are the 5 agencies for these purposes, whatever notification we come up with under this clause 18. As to, but your other question I think is more interesting, and I think your other question is more interesting, which goes back to which actually goes to what's this business of consistencies with overlaws. I don't think, for example, that it will depend, right? If they say UIDAI and everything to do with the UIDAI is exempt, then potentially what the PDP bill or the PDP bill says will override and supersede any protection that you might have under another different statute.
Under the Aadhaar Act.
Under the Aadhaar Act.
Okay. Anyone questions? Does this bill in any way prevent or enable, so one, prevent, to enable Pegasus like surveillance? Anand, by the way, deposed before the committee is...
Yeah, but no, I don't think so. Like, the answer to all your questions is I think it's like no. And that's because the law gives the government the power to exempt any part of itself from any part of the law. As long as that exists, I think that like as a strategic question from strategic litigation, is there scope to say law said that we have a fundamental right to privacy. When the court asks you questions, you say we'll come out with a law. You've come out with a law. The law does not address the things that you said, that the court said that you should. And this is how the law can be better. Yeah, sure. Like I think that's at a high sort of strategic level, or that there is a dire need for that to happen, because that's the only real way to hold the government to account for when it's not following things the Supreme Court said it should in Prasanna. But apart from that high level thing, and depending on what the court says there, you can go in different directions. But apart from that, there's nothing in this law, nothing in the 2019 law actually really. A lot of the things come on, you have to give the reasons for exemptions in writing. That's the kind of change, level at which we are, where as long as we say for national security, it's done. So the reason the 2018 law was considered as great as it was when it came out was because people have been pushing for this, with the Supreme Court, with the PUCL case and phone tapping and things like that for 25, 30 years. And the fact that there was a law that was going to actually say these terms was very, very powerful.
This overrides Prasanna? Sorry, not Prasanna, PUCL.
Sorry?
Does this override PUCL?
No, but also if you look at what PUCL did with what if you look at what PUCL laid the process that has to be followed when you do surveillance, and when you look at the process that was established, it is actually a lot of these things. There's review, you have to give a reason. How it happens in practice now is just en masse renewal again and again. SFLC did some work around it some time back. But if PUCL were to happen today, and if it was under the current way and scale at which surveillance can take place with technology, I think the process changes that would recommend would be very similar to the ones that are there in the 2018 provisions. It would ask for limitation, it would ask for due process.
I think we're quickly emptying out, so I'll come to you. I have one last question before I come to you for the final question. One of the things that I've been thinking about from a deployment of CCTVs across different states, and we've covered a lot of those deployments, or at least those tenders on Media Nama, is that there's also facial recognition requirements that are open. I have to put this firmly, there was a requirement of a law for any further inclusion of privacy. Right? So, does this law then effectively enable some of those ambient data collections and facial recognition that's being done at the back end? And so, will we need no more laws in order to enable more and more government surveillance in the public?
That will depend again on what is the nature of the exemption. Right? You have to have, if you don't have, look, what I suspect might end up happening is you might see a broad-based, sorry.
Notification will come, but does the law then create the grounds for enabling that kind of activity?
I still think that you need to have, again, it goes back to something that I was saying in different contexts, right? It will depend on the judge, it will depend on the bench that you're linking today. But if you want to read this generously, I would still think that despite having that kind of exemption, notification, you would still need some level of detail in it. I don't think a blanket exemption, for example, that says we can do whatever we want to and we are going to deploy facial recognition technology across the board. Right? I think it would have to be use case specific. I do think that you would have to have some element of specificity in whatever exemption you are prescribing for yourself, for you to be able to meet the Kutteswamy standard. Otherwise, it's just, it doesn't make sense. There is no, what is the purpose that you're begging it to? Otherwise, do you disagree?
I agree. I just like the word is. I think the word is it would legitimize certain forms of actions that currently take place in a vacuum. But if, for example, if I were the Indian government, I would not exempt the Indian Railways from having consent notices for CCTV cameras that it puts up. I would exempt the police from having to give the Indian Railways a reason for when they ask that data. I would exempt the police sharing it with other law enforcement agencies, but I wouldn't say any camera that the state government owns does not have to comply with any provision of the law, because you're also setting yourself up for like challenges and things like that, that when you do like strategic, like it's just, yeah, exactly. But I think in practice that it's the legitimization angle that is more important, because right now, and I said this earlier, the large reason why everything that happens in surveillance in India happens is because there is no law that governs it. Agencies exist on executive orders, there is no act, like, and when you pass a law that says it can exist, and then you pass a notification under that that's saying therefore you are exempt, that's when you're actually creating a legal justification for its existence, which is deeply concerning. Because right now it's the lacuna that is being used to justify its existence, but this will create a way in which you can say that it can exist and it's okay for it to exist. And the principle there is, I think, like a one.
I'd like to have seen a definition of the word national security, but okay. Similar question, come on, think of another one. I'm the only one asking questions. Anyone else questions, answers?
I was afraid about it, whether it could lead to, like you did say, rebellion could lead to a snowballing rather than protection. Because in every sector the government can pass, but can they also pass? And now I guess they can pass for private sector also by exemption. So it's just like it's defeating the entire thing. It's similar, that's why.
Yeah, like, I mean, I think the ways in which the government would want to retain the data that it does, I think it already does that. The VPN certain rules that happened earlier this year, like, you can see it consistently that the government has enough powers and other legislative frameworks to be able to require that data retention take place to the extent that it wants. And will this law therefore make it much worse? I don't think so, because they already have enough power and ability to do that. But what I think it would do is that, for example, if there's an agency that has to like make a request, what I would be very curious to see is how does the provisions of this law interact with like the internal executive memorandum that governs how, say, like agents of the enforcement directorate can demand for information and data. Where right now they've been created with like avoid bad press, avoid like embarrassing things, but get what you need in order to do your job. What this creates is like an overall or overarching justification that I think is much harder to digest.
I think then you just apply together, right? Because the nuances, in addition to the last point that Udbhav was making, how does it interplay to the extent that there's no conflict, it will apply in addition to. So you will continue to be governed by your internal memos as long as they are not conflicting with this law is saying. But if there is a conflict, then the law will prevail.
So if there's a legal justification, it means I can't even challenge it in court. If there's a legal justification for this stuff, it means that I can't even challenge it in court, which I might be able to if there's a lacuna, there's no law.
No, you can, right? Because the existence of a law and legal grounds is just one thing. right? There has to be a legal justification. It has to be necessary. It has to be proportionate, right? You have to be able to make out that sort of entire case. And a lot of it, again, like Udbhav was saying, we have to see how these challenges to surveillance law, reform, etc., play out. But if there were to be a situation where somebody, a judicial officer, had applied their mind, it wasn't a purely executive decision, you had thought about it, not just a legal reason, but plus. It's all of these things have to come together.
How does this law address this mass? Practices know that are already aware, and they've been happening for a while. And so, what I want to know is forget about specific CDR access via CMS. Yeah, that at least comes in the Telecom Act. Of late I know that they've been doing what, 10,000, 20,000, 30,000 a month. So no one applies that mind. You can practically guarantee that. But forget about that. They also get quite a lot of CDR records in bulk of personal space coming and saying it's bulk data. How does that apply? That's it. Just say guys, no.
I don't think it does, right? Like there is pretty much like for the history of how we arrived at this iteration of the bill itself. I don't think the kind of situation that you're envisaging was necessarily addressed even by the Shri Krishna draft going back to 2018. There was more there perhaps that gave protection, but the committee even back then was very clear that it was focusing on other aspects of data protection and wasn't getting into the question of surveillance law reform at all, right? They wanted that kind of arm's length distance. And I think that history
necessary and proportionate clause still brings some amount of control, right? It's not proportionate to take bulk CDR records.
Sure, but again, necessary and proportionate is a constitutional standard that applies agnostic of whether it finds its place in your personal data protection law or not. You can still challenge bulk surveillance, go to court and say, hello, Putteswamy violation, and the court will have to entertain you. So my reading, and you may disagree, is that it's great to have and we should have it in law, but materially does it prevent the legal standard from being applied? No, it doesn't. And I think that legacy is carried forward into this draft as well. Surveillance law reform was never the intent of the bill, even from its very first iteration. And here I don't think that the government is going to, stick its neck out and say, this is a cat that we want to pell right now. It's not.
Absolute last question there. We have to close and there's tea outside in case anyone wants.
Yeah, sorry, I missed the initial part of the discussion, so I don't know how much of surveillance law is discussed. But this entire CMS, NETA, NATGRID, there seems to be this entire, at least these three that I keep hearing about, where there seems to be ongoing monitoring happening. Is it completely without any kind of regulation control?
And the law is created in a manner where those are the programs that will be exempted from any part of this law applying to them as well.
On that positive note, thank you both for being so patient. Thank you for staying on longer. Thank you all for staying on. Please do file your comments in whatever little boxes that the Ministry of as MeitY has enabled us to do at MyGov. If you want, you might also want to email